in Georgia, where a man was arrested in the cold case murder of a University of Georgia law student. And this guy was fighting for bond. 48-year-old Edrick Faust, arrested earlier this year in the 2001 murder of law student Tara Baker. And firefighters discovered her body when they went to an apartment fire there, and they say that she was sodomized, she was strangled, and she was stabbed.
True crime just got darker. Catch the full episode on the link above. Subscribe to Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.
in Georgia, where a man was arrested in the cold case murder of a University of Georgia law student. And this guy was fighting for bond. 48-year-old Edrick Faust, arrested earlier this year in the 2001 murder of law student Tara Baker. And firefighters discovered her body when they went to an apartment fire there, and they say that she was sodomized, she was strangled, and she was stabbed.
True crime just got darker. Catch the full episode on the link above. Subscribe to At Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m. You're watching At Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere. Welcome to all our new followers from our sister channel at Truth Talks Live. You're watching At Southern Sin, your home for true crime. Hop over and hit that subscribe button. Welcome to all our new followers from our sister channel at Truth Talks Live. You're watching At Southern Sin, your home for true crime. Hop over and hit that subscribe button. Welcome to all our new followers from our sister channel at Truth Talks Live. You're watching at Southern Sin, your home for true crime. Hop over and hit that subscribe button. You're watching at Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere.
No, I need to speak.
Okay, all right. I'll let you do that. Do that and let me know. I think I'm just sort of thinking out loud. I think that's
Smart founders know something most people miss. Get your domain name even if you're not ready to launch your business. With Wix, you can grab
the same WebEx at the same time.
Okay.
Yeah.
Wait to the motion in limines because that may
Okay, sure. All right, very good. Any motions you want to present, Mr. Yelman-Chile?
Yes, Your Honor. Thank you. My understanding is, at least in part, we're not sure who all of the witnesses are going to be that Mr. Cruz calls, but it is my belief that he intends to recall Detective John Newton, as well as call Detective Mike Tyndall and Kashana Armstrong. As it relates to Detective Tyndall, the state would make a motion in limine regarding any testimony about alternative suspects other than Mr. Melton, as has been referenced several times during the trial of this case. In pretrial motions, the state filed a Saudi motion. Mr. Cruz identified only Chris Melton as an alternative suspect that the defense would offer before the jury. Detective Tyndall, I think it's actually Sergeant Tyndall, if I'm recalling correctly, is a law enforcement officer now with the Oglethorpe County Sheriff's Office. At the time, he was with the Athens Clark County Police Department. In part, he interviewed individual by the name of, Stephen Barden, who was a law student at the time, and motion in limine. Also, it's our belief, and obviously we do not know this for sure, that Mr. Cruz may be intending to attempt to question Mr. Newton and Sergeant Tyndall regarding certain phone records for which there is no records custodian who has appeared on the witness list in order to testify to authenticate those records, and no notice of intent to introduce the records without a records custodian has been filed. Obviously, we ran into this issue with another witness, which is why the state is making a motion in limine at this time that those records should not these witnesses do not have the ability to authenticate those records in an appropriate way to lay the foundation for their admissibility. And so those records should not be used as a methods of questioning these witnesses or raised as far as their contents in reference to the questioning that Mr. Cruz would do, or, even if they're not admitted into evidence, the information in them cannot then be used in the questioning in an effort to introduce hearsay evidence through questioning of witnesses who aren't able to lay the proper foundation for the admission of those records. So those are the motions in limine that I wanted to present, Your Honor. And I know that the way we've split up the cross-examination of possible witnesses that Mr. Cruz may call. If I could have just a moment to consult with Mr. Bolden.
You can. But you were talking about the phone records with regard to the witness. Mr. Cruz is calling Sergeant Tyndall. Is that right?
Sergeant Tyndall and Mr. Newton.
Oh, and Mr. Newton. Okay.
In the recall, I believe there was an attempt the first time that Mr. Newton testified in order to introduce those business records, and the court made a ruling that there was not a proper foundation
referenced that in his opening statement. The state would move to exclude any testimony by Mr. Newton as it relates to his conversation with Ms. Gann. First of all, it would be hearsay. And second of all, even if there were an argument that it is not hearsay, and I think that frankly the analysis should end there, but even if the court were to find that it is not hearsay or it is an exception to hearsay, at this point we would object on grounds under 401 and 403. It's not relevant, and any conceivable relevance is substantially outweighed by the risk of confusing the issues and misleading the jury. And in that regard, I would point out that the uncontroverted evidence at this point, in the form of the testimony of Ms. Lonstein last week, was that Ms. Baker was in the law school library until at least 9:46, when Ms. Baker called her to make sure she got home safely. And so the idea that she could somehow simultaneously be at a Mexican restaurant on the east side under the influence of alcohol is just not borne out by the facts. So the state would object to any testimony, any attempt to elicit testimony from Mr. Newton regarding that conversation.
All right, thank you. Anything else?
No, Your
All
Honor.
right, Mr. Cruz, several motions on the table. Go ahead, sir.
The only two that I'll address is first I'll start with, and good morning.
Good morning.
Board. First I'll start with Stephen Barden. I do intend to introduce that evidence, Your Honor, and not for the purposes of showing him as an alternative suspect, but for the purposes of showing that they had Mr. Chris Melton and this evidence leading to Mr. Chris Melton. And instead of executing a search warrant on Mr. Melton, the investigators decided to terrorize Mr. Barton and execute a full-blown search warrant on his house, obviously because he had nothing to do with Ms. Baker's murder, turning up no evidence of her murder. But these same actions were not taken with Mr. Melton. So the sole purpose of that testimony would be simply to, as we stated in opening, as we've maintained this entire trial, just to show that this investigation was not thorough. It was directed away from Mr. Melton at every twist or turn. In regards to Mr. Newton's testimony, in regards to Jessica Gann, as far as hearsay, we're not offering Jessica Gann's statements for the sole purpose of the truth of the matter asserted. Similar to the questions we asked about Ms. Shauna Armstrong, we're offering the information about Ms. Gann, again, to show that the investigation was not thorough, the early investigation. Law enforcement was aware of this information. They did not provide Ms. Gann with a photograph of Ms. Baker. They did not do any type of, I don't want to say a lineup, but they did nothing to follow up on the information with Ms. Gann. They got the information, they just ignored it and moved on. And that information also impeaches the state's position. The state's position is simply that because Mr. Faust's DNA is present, that means he's responsible for every single count in the indictment. One piece of evidence they have not shown, they haven't presented anything showing where Ms. Baker was the night before her death outside of the library. And in regards to the timepiece, I think that's more appropriate for cross-examination as opposed to a motion to eliminate. And the reason why, Your Honor, is the state has defended multiple witnesses on their time discrepancies. Even time discrepancies that occurred closer to the crime. I believe Ms. Gann might have been interviewed, I believe it was 7 days after. So if she wanted to give and I believe the state made this argument in regards to a particular witness. I can't remember the witness, but if she wants to make an approximate time, hey, I believe it was 9:30, maybe 10 o'clock. I don't know what she said because we only have the report, but I believe it was around 9:30. That's something they could flesh out with Detective Newton during cross-examination, Your Honor. So those are the only two motion eliminates we would seek to address with the Honorable Court. In regards to the phone records, the Honorable Court knows my position with the records. I respect the Honorable Court's ruling. I think you've made it clear that we are not to present any phone records of anybody at any time. So that's an issue that the Honorable Court has already ruled in the state's favor on. So we disagree, but we follow the Honorable Court's ruling.
All right, thank you, Mr. Cruz. I'll start with the phone records. the issue with the phone records was not necessarily a blanket instruction to prohibit testimony of phone records. The ruling was based on the lack of defense counsel's, for whatever reason, lack of providing the proper witnesses to bring those phone records in. And without the proper witnesses subpoenaed by the state, phone records are not allowed under law. And so that's the ruling I made. I want to make it clear for the record that the court's ruling was not a blanket. The defense cannot bring in phone records. Certainly, there might have been, if you had subpoenaed the proper people to bring them in. We could have had another hearing as to whether they were relevant. I mean, I'm not making a comment that they would necessarily be admissible, but just the ability to talk about them is based on the lack of ability to produce the proper foundation. I know we argued that at the bench, but I want to make that clear.
Can I respond to that?
You may.
The state, we had a hearing on this. I asked for out-of-state subpoenas regarding the phone records. I advised honorable court at that hearing that Sprint, and I believe, I can't think of the other company, but the companies were out of business. They sent me emails stating that because the records were so old, they did not have a way to verify those records. The state explained to the honorable court that they would I'm looking for the proper word, but I don't have it now, so I'll just say they would agree that for foundation purposes, the records are admissible. They said they would object on hearsay grounds, things of that nature. But our argument was that the records aren't hearsay because they are computer-generated records as opposed to a statement by a person. Just to put that information on.
Well, let's talk about that because we did have a hearing with regard to those issues. There are a lot of phone records that we were sort of talking about at the time.
Correct.
So let the state respond. We can talk about that. Go ahead.
I'll be happy to respond, Your Honor. That hearing did occur. At that time, we had been in for several weeks, I believe, attempting to discuss and lock down stipulations with Mr. Cruz, and it was the state's belief at that time that we were going to be in a position where Mr. Cruz was agreeing to stipulate as to the foundation for certain crime lab reports. And in exchange, the state would be willing to stipulate to certain phone records and also crime lab reports from North Carolina in the form of some mitochondrial DNA analysis. However, Mr. Cruz never gave the state a response despite repeated requests to give us an answer as to whether or not we had stipulation. I drafted a list of proposed stipulations and I gave them to Mr. Cruz in the form of a physical document, I believe on the first day of jury selection. After reviewing that document and consulting with Mr. Faust, Mr. Cruz informed the state that at Mr. Faust's direction, the defense was refusing to stipulate to anything. So an offer was made and denied by the defense. And at that point, there were no stipulations, and the state has endeavored to call the appropriate witnesses to admit the evidence that it intended to admit via stipulation, and was certainly something that was available to the defense as well. But as the court noted, for whatever reason, those witnesses haven't been present in order to lay the foundation. So that's the context in which stipulations were discussed and then refused by the defense.
All right, thank you. Anything further, Mr. Cruz, based on Mr. Yelman-Shilly's comment?
No, that's accurate.
Okay.
We refused
Okay.
stipulation.
Okay.
Correct.
All right. Thank you, sir. So I think based on that, and I do remember certainly the hearing, I can go through and look at my notes. They aren't in front of me at the moment in the order that the court signed. But I would just say, I mean, I'm going to grant your motion with regard to the phone records, Mr. Yelman-Shilly. I think that is appropriate legally at this point. If a stipulation is not entered, as was announced in court that you all would be able to work that out, the court would have had to know that in order to specialize or set a special time, I should say, to hear the rest of your motion, Mr. Cruz, to decide whether your motion was appropriate and whether what you were asking for could be granted, and that hasn't been done. I can't do it certainly in the middle of trial. So I'm going to grant your motion with regard to the phone records. With regard to any testimony from Mr. Newton with regard to a witness that you wanted to call, Jessica Gann, let me ask you this so I'm clear on what you're saying. Well, let me just ask you, what is your position on the state's objection about hearsay? Yes. I mean, they've objected on other grounds as well, but what about the
It
hearsay?
goes to notice. That's my response. It's not hearsay because it goes to notice. That law enforcement was on notice about this information and they didn't follow up on it. We're not offering for the truth of the matter. We're offering it to show law enforcement, which is one of our multiple defenses in this case. I think a big part of the state's case is that law enforcement had information that they just failed to follow up on that would have resolved this case 20 years ago. So it's just notice. This goes to notice that law enforcement was aware of this fact and they didn't follow up on it.
Thank you, sir. I think at this point, what the law would require, Mr. Cruz, is that if the defense's argument is that these statements that certainly I would say at this point would confuse the jury about anything that may have happened at a Mexican restaurant with a person's statements who have not been elicited in court at all. I certainly would say that under 403, we are talking about confusion of the issues and misleading the jury. I think that's certainly a problem. But I would say that at this point, Mr. Cruz, the defense would have to provide evidence to what you've just stated. I mean, a blanket statement that you're making that if law enforcement had followed up with Jessica Gann, this case would have been over 20 years ago is that's a pretty spectacular statement. And in order to ask the court to admit those statements in lieu of that comment, the defense has to provide the court some evidence that that would in fact have been true. And without that evidence, that testimony that you are seeking to elicit, certainly I would say falls under the category of misleading the jury, of confusion of the issues. And it really does come close to that line that we have been discussing this entire time, which is the order that there are to be no statements by witnesses about other suspects other than Chris Melton, which you properly gave notice to the state for. So, you certainly can respond to what I've said, and then we're going to kind of move on, but go ahead.
So two things. My statement, I think I may have said it wrong to take it out of context. So my statement wasn't, or it should not have been, forgive me if I said it this way, isn't that, hey, if they solely would have talked to Jessica Gann, this case would have been resolved. I believe I stated it the wrong way. What I was saying is if law enforcement would have followed up on all leads, this case would have been resolved. As far as the 403 ruling, Your Honor, the state didn't object on the basis of 403. I understand the court could make any ruling that it deems appropriate, but the state did not object on 403 grounds. The state objected on hearsay grounds, and we provided our response to the hearsay. I would like the opportunity to provide a response to the Honorable Court's objection regarding confusing the issues for the jury.
You certainly can. I thought Mr. Bolden did make a 403 argument, and that's fine. I'll let you respond regardless, but I think he did. But the court has an obligation, regardless of whether the state or the defense talks about 403, the court has an obligation to respond to 403. So you certainly can respond.
Sure. So in regards to 403, as far as confusing the issues, this statement from Detective Newton wouldn't require a mini trial to determine facts of issue. It's simply a building block on the facts in this case that support our position. I don't think that one fact I think we're on the 9th day of evidence, maybe? We're on the 10th day of evidence. We started last Monday, if I'm not mistaken. That one fact out of 10 days of evidence, I don't believe that will confuse the jury where they say, hey, we don't know what the heck is going on in this case. I can't believe Jessica Gann said that she saw Miss Baker. So that would be my response. I do not believe that one fact would confuse the jury, Your Honor, and I'm not sure. Did you say waste of time also?
I did not.
You said confusion of the issues and one more.
Misleading the jury.
And my argument would be the same. I don't, out of 10 days of testimony, and of course, the Honorable Court has all the wisdom, I don't believe that one fact would mislead the jury to making a decision in regards to the indicted charge where they say, we have this fact. Now we don't know if Mr. Faust is innocent or guilty because of this one fact. So I asked the Honorable Court to reconsider its ruling under 403.
All right. Thank you, Mr. Cruz. I mean, I think the argument you've just made supports the court's conclusion that any evidence regarding this Jessica Gann person first of all, it certainly sounds like hearsay. I understand what you're saying, Mr. Cruz, that you're not offering it for the truth of the matter, but I think there's an argument to be made that you are. But I'm not finding that it's relevant. I think at this point, given the comments that both counsel has made, it would be incumbent upon the defense to provide evidence as to why any testimony by Jessica Gann would be relevant. And so I'm going to grant the motion. I'm going to find that it is not relevant. It is hearsay, and there's no exception to overcome the hearsay. Under 403, I certainly do think at this point, bringing in another person to suggest evidence that is not supported is a very significant moment of misleading the jury and confusion of the issues. And so under 403, I'm going to grant the motion as well that Mr. Bolden has made. There will be no testimony allowed to be elicited from Mr. Newton about Jessica Gann. No testimony elicited from Sergeant Tyndall regarding contents of phone records unless you can present a witness that can lay the proper foundation. Let's make this clear, though. I want to talk about this. Is there an objection from the state? Let's do this right now about Mr. Cruz asking Sergeant Tyndall whether he was able to get phone records.
And that's what can I respond before this? He
Sure.
laid the foundation for the phone records.
Sure.
The court order he obtained via recognizing the phone records, via stating that
Right.
those phone
Right.
that they didn't appear to be altered. So he laid the foundation
Sure.
for the records that you received.
I remember that. I have that in my notes. But let's just get this out now so we're not having any, problems
I
later.
do not believe that there is anything wrong with asking Sergeant Tyndall if he obtained phone records. However, whether the police officer got phone records back as part of his court order is not the proper foundation for admissibility of those phone records.
I understand.
And so that's what our objection is to the
But
contents.
admissibility in the
The
context.
fact that he did in fact seek a court order, that the phone records were provided, are things that I think are appropriate questions that can be answered. It's just that any contents of the phone records cannot be asked about without the appropriate foundation witnesses, as the court's already articulated.
All right. Thank you. So I want to make sure, Mr. Cruz, do you have anything else you want to say about that or any questions for the court? I mean, I do think that's right. And Sergeant Lieutenant Tyndall has already testified, as you said, about those records. They are in my notes. Again, I don't have it in front of me, but was Newton? Yes, ma'am. Yes, ma'am. Sure. Got the microphone again.
Newton
All right.
was the
It was Officer Newton?
I don't believe Tyndale has testified at this moment.
That's right. It was Officer Newton. Okay, so let me just make sure we're clear. And I do recall the testimony. It was Mr. Newton, former Officer Newton. Are you intending to ask Sergeant Tyndall about phone records as well, obtaining phone records?
I am only going to ask Sergeant Tyndall about things the honorable court permits. From what I understand right now, that is not permitted, so no, ma'am.
Well, that's why we're having this discussion. I mean, I think the question as to whether an officer in his or her investigation received phone records is certainly a permissible question. And I agree with the state's characterization of that as being admissible. I think it's the contents and the admissibility of what's in the records that's at issue. So let's
Right.
just flesh this out now, make sure we're on the same page.
So the contents, that's what's important to us, because I think it will establish the nature of Mr. Melton and Ms. Baker's relationship up until the day before her death. If the honorable court's ruling is that we are not to get into the contents of the phone records, and of course we put our response to the state's hearsay objection in regards to the phone records, so I won't go into that, Your Honor. But if the honorable court is saying, hey, my ruling is that you cannot get into the contents, you cannot talk about the phone records with the witness, I won't get into that.
All right. Thank you, sir. All right. So I'm not changing my ruling unless I'm presented with some other piece of information that is appropriate for the court to change its position without the proper foundation to be laid with regard to the contents of the phone records. They're not admissible in terms of the content.
Well, I do want to say this just to make it
Sure.
clear for the record. The foundation was laid by Mr. Newton. I think the disagreement between me and the state is saying it's hearsay, and I'm saying that it's non-hearsay because they're computer-generated records. That's the only disagreement. And of course, the Honorable Court issued its order on that.
Sure.
I just wanted to make that information clear.
All right, thank you. So it doesn't overcome the hearsay because there does need to be a foundation laid in terms of the contents of the record. And so of the records. I'm not going to change my order on that. A foundation has to be laid. They are hearsay. And unless the witness is a custodian of those business records, can testify to them as would be required under law, I am going to rule that the contents are not admissible. The questions about whether an officer received phone records is an admissible question. Mr. Yelmichel, did you want to add something before we finish this phone records conversation?
Just briefly, Your Honor, I'm sorry, I should have mentioned this before. We would, although it's perfectly fine as from the state's perspective for Mr. Cruz to ask about whether or not Sergeant Tyndall or Mr. Newton received phone records, we would say that any affidavits that were submitted by the law enforcement officers in order to receive the court orders to get the phone records and the court orders themselves, I don't think are admissible as evidence, as substantive evidence in the case. Just the questions are appropriate, but I don't think those documents, as far as the affidavit, would be admissible and would be able to be submitted to the jury.
Okay, and tell me why you don't think they're admissible. What would be your argument?
Well, Your Honor, those affidavits are within them going to necessarily contain some hearsay information since they are, the officer's statement and affidavits for purposes of receiving court orders or search warrants are not limited by the rules of hearsay when they're being submitted to the judge. Now, if there were certain portions of them that serve to contradict testimony that the witness gave about things they did or did not do, then they may be admissible for the limited purpose of impeachment on those issues. But just simply tendering a law enforcement officer's affidavit, I do believe would contain hearsay statements within it and also contain their opinions on certain things and various other things that wouldn't necessarily be admissible in the context of a trial before a jury, although they would be appropriate for the purpose of having obtained the court order to begin with.
All right, thank you. Mr. Cruz, care to be heard on that?
No, ma'am.
All right. Then I think that's right. I mean, that's, I think, a correct statement of the law. I would say, however, in the same vein as questions about did you obtain phone records is an admissible question. I think certainly, and I'm not telling you how to do your examination, but if you chose to ask the officer, did you seek a search warrant for phone records, that is an admissible question. And unless you want to be heard on that, Mr. Yelmichel, I want to make sure sort of we're clear that there are certain things you certainly can ask law enforcement about their investigation, and asking for a search warrant and did they go seek one is an appropriate question. I think the contents of what they received would probably not overcome a hearsay objection. If you feel otherwise at the moment, we can take it up outside the presence of the jury. All right, with Armstrong, or is it Keyshawn Armstrong? Keyshana, all right. There was a motion in limine regarding any comment about another person with a name. Was it Scott? Was that? Hold on just a minute. Let me make sure I've written this down right. Did you make the motion about Ms. Armstrong? Was that you, Mr.?
I don't believe the state has any motion in regards to Ms. Armstrong.
I wrote down Ms. Armstrong. I thought there was something about Mr. Another person who they did not. You didn't bring evidence. Bolden, is that correct? Or Bolton?
I hope not.
I'm sorry. Was it Bolton?
Barden.
Barden, sorry. Barden. Okay. I'm not sure I wrote it down. And you were expecting that information to come through Ms. Armstrong's testimony?
Well, no, Judge. It was Sergeant Tyndall.
That was Sergeant Tyndall. Okay.
Yeah, it would be Mr. Barden and then also an individual by the name of Anthony Little. These would be two people that were considered persons of interest at the time. However, no information was developed to link them to the crime. And it was our belief, or at least we thought it might be a possibility, that Mr. Cruz is attempting to elicit testimony regarding those individuals from Sergeant Tyndall or Mr. Newton. I mean, just our motion in limine has to do with those two individuals just being mentioned in any way, since Mr. Cruz did not identify them as individuals he intended to raise as alternative suspects in response to pretrial motions hearings.
All right, thank you. All right, I don't know why I wrote Miss Armstrong's name down, and we have to get her WebEx information. That may be why I wrote it down. You have the information, fantastic. All right. Mr. Cruz, do you care to respond any further with regard to the remainder of the state's motion in limine as it concerns any person by the name of Baden and Little, last names?
Baden and Little?
Baden and Little. They were just referring to two. Barden? I'm not going to get it right. Barden. Sorry. Barden.
I believe I put that information on the record for the honorable court, our position, that nothing changes from our position.
Okay. All right. Thank you. I'm going to grant your motion. It does violate the Sadi motion the court has granted in previous hearings and that we have been discussing throughout the course of this trial. And so I'm going to grant your motion. There will be no testimony about anybody by the last name of Barden and Little through Sergeant Tyndall or Mr. Newton. It would violate the court's previous ruling. So, all right.
Your Honor, I hate to jump in on that. There was another piece of this that I think because Mr. Yalamanchili and I are kind of splitting up potential defense witnesses today, Mr. Newton also spoke with an individual at the Clark County Jail back in March of 2001. That person provided some other names of people who were allegedly making admissions or whatever about being involved in this crime. The inmate with whom Detective Newton at the time spoke, her name is Melinda Thomas. The information she provided is secondhand hearsay about what some other people would have told her. These are not as it relates to Mr. Little or Mr. Barden, but under the same theory, the state would ask that any testimony about these other alternate perpetrators or potential alternate perpetrators also be excluded.
All right. Thank you. Mr. Cruz.
Just for clarity, Your Honor, and I may have said it wrong or misspoken.
Okay.
But these individuals, I'm not saying they committed a crime. Alternative perpetrator ruling, I'm not saying any of these individuals committed a crime. So I may have explained it wrong. The purpose of Steve Barden is to show the investigative steps. It has nothing. Our position is firm. Chris Melton committed this crime. We're not saying anybody else committed it. So if I say something that sounds like I'm saying, Judge, we want to point the finger at this person, we want to point the finger at that person, I'm just misstating. That is not what I'm saying. Anything that we're seeking to bring in at this point in our case in chief is to show the failures of the investigation. They have nothing to do with whether a person committed a crime. They have nothing to do with hearsay. It's just whether, did you have notice of this fact? Did you follow up on this fact? If not, why? That's our entire theory with the witnesses. As far as the witness Mr. Bowden is speaking about, I just want to make sure we're talking about the same witness. May I see because there is one I wanted to discuss with.
All right.
So I, in fact, do intend to speak about Ms. Thomas. I wasn't going to refer to her by name. I was just going to say, did he speak to an inmate? And the purpose of this testimony is just to show, and I'll put it this way. It would be in sir rebuttal if the state has a rebuttal to our defense. So we wouldn't get into that information with Mr. Newton in our case in chief. But if there's rebuttal, this testimony will become relevant as sir rebuttal, depending on what the state's rebuttal is. So I would ask the honorable court not to make a ruling at this time until defense rests and the state lets us know if they are going to have rebuttal evidence in regards to the evidence that we present.
I'm not really sure I understand what you're asking, Mr. Cruz, about the rebuttal evidence, but I do want to respond to your arguments that relate to the state's. I'm actually looking for the order that I wrote with regard to this whole issue. Your responses to the state's motion in limine with regard to Mr. Barden, Mr. Little, this unknown person at the jail.
We don't have anything from Mr. Little. We didn't intend to elicit any testimony about Mr. Little.
Okay. But I'm going to mention this person in general because they all relate to the same thing. I understand certainly what the defense is saying about their position that the state law enforcement did not investigate this case properly. And I understand what you're saying about notice, and that is those positions are the reason that the statements about other persons should be properly admitted. I understand what you're saying. The problem with that legally is this. The defense is asking for the court to allow it to go to admit those statements under that theory. And in doing so, that would bypass the court's order that it has already granted the state, which is that if there were any alternative suspects that were to be discussed at trial properly, the defense had to provide the proper notice, which would then allow the court to set a hearing so that we can determine whether the statements being offered about alternative suspects are admissible for lots of reasons, whether they would be admissible with regard to a hearsay objection, particularly whether they would be admissible because of relevance. And so just by stating, well, we're asking to admit those statements under a different theory, it is not appropriate for the court to allow that, because what that does is circumvent the prior order. They have to be done in conjunction. And so if the defense wanted to elicit testimony about other suspects for the purpose that you're asking for them to be elicited, notice under the Saudi motion we've been talking about had to have been done in order for the court to have in order for the state to have gotten the required notice, and in order for the court to have set a hearing date in order to flesh this out. And that hasn't been done. And so I understand what you're saying, but it is not appropriate to circumvent the order by saying, well, it's just under another theory. That motion was not filed by the defense for whatever reason. And I'm not commenting on that. That may certainly be a strategic moment on the defense's part. But it hasn't been done. And because the proper notice hasn't been done, in order for the court to make a ruling that regardless of the state's feelings about those statements, regardless of any other legal objection that we've discussed in those hearings, those statements would be proper. The court hasn't had that opportunity because notice wasn't filed. So I'm going to grant the state's motion based on those for those reasons. All right, but I wanted to kind of make that clear. All right. Let me start again with the state. Anything else we need to take up before the jury comes back in?
No, Your Honor.
Okay. Mr. Cruz, is there anything else we need to talk about before?
Well, based on the rulings, I would like 10 minutes to talk with everybody because we have to figure out what.
Absolutely. So I think what we're going to do is this. We have your information for WebEx. We're going to go ahead and just get that set up. I'm going to give you all till 10:20. All right, so that's about 25 minutes. I'll be back on the bench at 10:20, and then we'll get started. All right, we'll be in recess until then. Thank you.
Your Honor.
Yes.
I need to speak with Mr. Faust too, so he'll need to be a part of that discussion. Can we make that happen? Mr. Faust would need to be a part of that discussion as well.
He can absolutely remain here. No problem.
Thank you for subscribing to At Southern Sin. Keep our algorithm high by hitting the like button now and use hashtag Sinners in the chat to win a free membership.
Welcome to all our new followers from our sister channel at Truth Talks Live. You're watching at Southern Sin, your home for true crime. Hop over and hit that subscribe button. You're watching at Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere. You're watching at Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere. You're watching at Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere. You're watching at Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere. You're watching at Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere. Welcome to all our new followers from our sister channel at Truth Talks Live. You're watching at Southern Sin, your home for true crime. Hop over and hit that subscribe button.
I'm getting this to you in Word format.
I'm sorry?
Getting the jury instructions in Word format. I understand you received it.
Oh, that'd be great. Thank you. All right. Let's go on the record. Mr. Cruz, have you had enough time to have the conversations you said you needed to?
I have, Your Honor.
Okay, very good. Are you ready to?
You're watching at Southern Sin, your home for true crime.
All right.
Court will begin shortly.
Before you bring the jury out,
Don't
let's
go
talk about
anywhere.
a few things. I want to talk about timing, some timing issues. Let me just have counsel at the bench so we can sort of have a more of a free-flowing conversation.
You're watching at Southern Sin, your new home for true crime. Smash that like button now. We'll be right back. You're watching at Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere.
Thank you. You all may be seated. Welcome back, ladies and gentlemen. Appreciate you all again being here on time. We are ready to resume State of Georgia versus Edrick Faust. SU 24 CR 0547 is state ready. State ready?
Ready, Your Honor.
Defense ready to proceed?
Yes, ma'am.
All right, ladies and gentlemen, the state has rested. Mr. Cruz?
Defense rests.
The defense rests as well. Ladies and gentlemen, that means the evidence in this case is closed. So now this is what we are going to do, and I want to tell you sort of how the process works. The evidence is closed in this case, and the next step for all of you is to hear closing arguments. There's something that has to happen before that, and it's called a charge conference. And it is a conference, it's a meeting with the court and all the attorneys about what law is to be given to the jury in its charge. That is something that, of course, has to be done outside your presence, as we have done many things outside your presence during the course of this trial, including this morning, which is why I had you come in later, because we were doing things outside your presence, and I just didn't want you sitting in the jury room for, when you could be at home or doing other things. But this charge conference, of course, must happen outside your presence, and it's going to take us a while to do it. I'm going to give you a very long lunch break. I'm going to give you a lunch break until 2:30 this afternoon. And so I'm going to ask you to return back here at 2:30. I know one of the jurors has an appointment. Don't rush to come back if you're a little bit late. It's fine. We will not start without all of you being present, so don't worry. But if you'll come back at 2:30, we're going to begin closing arguments at that time. The same instructions I have given all of you apply, right? Don't discuss the case with anyone, of course. Don't do any research independently or on the computer. Please don't go to any of the locations you may have heard about. Enjoy your lunch. It'll be a lunch. Adjourn for the moment.
I guess you know what comes across my mind. Murder. Just murder, murder.
A lot of ladies think he's attractive. Very nice, very well spoken.
This is what I do with women, you know? I use my charm, use my good looks. I'm like a lion. You're the prey, I can sense it.
I stand here today to announce the indictment of Wade Wilson for the murders of Christine Melton and Diane Ruiz.
Both of them had been strangled. The last person that they encountered was Mr. Wade Wilson.
He said he got back in the car and ran her over until she looked like spaghetti.
I choked her out so she couldn't breathe anymore. I was on a rampage at this point.
He's still pulling the strings from a jail cell. He's got an army of wives. That's all he's ever wanted.
To advocate for someone because you think he's handsome.
A rage overcomes me. Just kill, kill, kill. When I get that way, I become the devil.
I'm gonna be honest with you, son. Everybody in the state thinks you're a monster.
True crime just got darker. Catch the full episode on the link above. Subscribe to At Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.
Is this Mr. Lloyd, Markeith Lloyd? All right, thank you. Let's go ahead and begin these first appearances. Sir, you're here for the charge of murder of a...
There ain't no Markeith Lloyd. Who are you?
All right, you're here for murder of a law enforcement officer, attempted murder of a law enforcement officer, carjacking with a firearm, aggravated assault.
May I have your name, please?
Is this...
Markeith Lloyd was captured, wanted for the murder of his pregnant girlfriend.
For real, you not about to kill me and the baby. This man, he has to be stopped. But no, you need a greater force than that. I'm not going to live past 25.
Most wanted man in Florida is waking up in a hospital this morning. Police captured Markeith Lloyd Tuesday night in Orlando.
Catch the full episode on the link above. Subscribe to At Southern Sin today for more exclusive crime episodes. Investigators could only conclude the unimaginable, that this weight had been used to crush her skull and ultimately the life from her. But the horror did not end there. Inside the master bedroom closet lay Gloria's teenage son, Caleb. Only 17 years old, bound tightly in tape, his lifeless body discarded like he was nothing. True Crime Tuesdays just got darker. Southern Sin's all-new episodes drop at 9 p.m. Subscribe now for exclusive content.
A summer night turned deadly when 17-year-old Alvin Foy unleashed chaos. On July 25, 2020, Foy and Jameer Manning fired 31 shots into a crowd on Essex Street over a petty dispute. A stray bullet struck 18-year-old China Forney, a high school senior, in the back, killing her as she fell in a friend's arms.
Prosecutors presented surveillance and ballistics, proving Foy fired the fatal shot. His not guilty plea crumbled as China's family spoke of their loss. Foy flashed smiles, then laughed outright, enraging the gallery.
Foy, on May 3rd, 2021, you are a co-defendant.
Excuse me, sir. Let the record reflect that the defendant is laughing during the victim impact statement.
Catch the full episode on the link above. Subscribe to At Southern Sin today for more exclusive crime episodes.
I just killed my mother. And
what happened, sir?
Earlier that evening, Champaign County dispatchers answered a 911 call from Shane's 14-year-old son. At first, it sounded like a routine emergency. But buried in the boy's trembling words was something far more chilling, an unsettling confession. The question wasn't just what happened inside that house, but who, exactly, was confessing to murder.
I just killed my mother. And
what happened, sir?
I just killed my mother, and I need to go to the hospital.
Captain Loney assures Shane his son is safe, tucked away in police custody. But behind the calm words, a darker truth lurks. As Shane's fear spirals, Loney tightens the net, asking pointed questions.
Give me a little history on your son. And is his name, am I correct, is his name Donovan?
Oh, God, yes. Yes, Donovan Asher Nicholas.
What's his date of birth?
Okay, I think he's 14 years old.
Okay.
But I don't know.
Okay. Has he been any behavior problem or anything to you?
Never. The boy is soft-spoken. He's a genius. He's very, very smart. He's non-confrontational.
Okay.
He's never done anything. No, this is not happening.
Has he ever inflicted harm to any family member or anything like that?
Never.
No harm to anyone?
Never. None.
Does he have friends and things of that nature?
No, he does not.
True Crime Tuesdays just got darker. Southern Sin's all-new episodes drop at 9 p.m. Subscribe now for exclusive content.
Rapper YNWMLE, whose real name is Jamel Demmons, back in a Broward County courtroom Monday as the state prosecutors and the defense are going over a number of different motions filed to see what will be admissible for Demmons' retrial. Demmons is accused of murdering Christopher Thomas and Anthony Williams, both childhood friends, back in 2018 after a late-night recording session, and then allegedly made it look like a drive-by shooting. His first double murder trial ended in 2023 in a mistrial after jurors failed to reach a unanimous verdict at trial, with twists and turns that included allegations of witness tampering, passing messages in jail, and alleged plans to escape. All issues brought before the judge today to see what would be permitted to use in his new trial. Demmons faces a number of charges that include 2 counts of premeditated first-degree murder and witness tampering. And he is expected back in court January 12th on Monday at 8:45, where the judge will hear additional motions. That trial has been set for January 21st.
Teenager Sarah Grace Patrick went public on social media after her mother and stepfather were shot and killed in their own home. But what happened next has everyone shocked, and it's chilling. Sarah was just 16 when tragedy struck. On a February morning, her 5-year-old sister discovered the bodies of their parents, Kristen and James Brock, both shot in bed. Moments later, Sarah called 911 and then posted tearful TikToks and a haunting eulogy online, ending with the words, "I'm sorry." Now, authorities say the story isn't so simple. Sarah faces 2 counts of murder and 2 counts of aggravated assault, and she'll be tried as an adult. Investigators say a mountain of physical and digital evidence points to her involvement. Her social media activity, reaching out to true crime TikTok influencers, has only fueled suspicion. With no clear motive, the community is left asking the same question everyone's asking. Why would a teen allegedly kill her own parents? The case is far from over, and prosecutors claim they have evidence no one has seen yet. Follow the live trial daily on at Southern Sin True Crime Just. The full episode on the link above. Subscribe to at Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.
Flores with Main Service on the Police Department.
Oh, hey, how are you?
Good. You need to talk to me about something?
Well, I just wanted to offer any assistance that I might have. I was a really good friend of Travis's, and I know that I don't know a lot of anything, but...
What have you heard so far?
I heard that he passed away and that... I don't know. I've heard all kinds of rumors. I heard there was a lot of blood.
When we first arrived on scene and started talking to people and some of his closest friends began mentioning your name. You know, hey, you need to call her because she probably knows what happened to him, or she possibly had something to do with it.
Looking for a good binge? The Jodi Arias murder trial is back. Relive the stunning testimony, explicit evidence, courtroom meltdowns, and the circus that surrounded the case. From sexual obsession to betrayal, this is the true crime case that captivated the world. If you think you know the story, watch it unfold again, raw and uninterrupted. The Jodi Arias trial, re-airing only on Southern Sin. True crime just got darker. Catch the full episode on the link above. Subscribe to Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.
Is this Mr. Lloyd, Markeith Lloyd? All right, thank you. Let's go ahead and begin these first appearances. Sir, you're here for the charge of murder of a...
There ain't no Markeith Lloyd. Who are you?
All right, you're here for murder of a law enforcement officer. Attempted murder of a law enforcement officer, carjacking with a firearm, aggravated assault.
May I have your name, please?
Is this...
Markeith Lloyd was captured, wanted for the murder of his pregnant girlfriend.
For real, you not about to kill me and the baby. This man, he has to be stopped. But no, you need a greater force than that. I'm not going to live past 25.
Most wanted man in Florida is waking up in a hospital this morning. Police captured Markeith Lloyd Tuesday night in Orlando.
Catch the full episode on the link above. Subscribe to Southern Sin today for more exclusive crime episodes.
A summer night turned deadly when 17-year-old Alvin Foy unleashed chaos. On July 25, 2020, Foy and Jameer Manning fired 31 shots into a crowd on Essex Street over a petty dispute. A stray bullet struck 18-year-old China Forney, a high school senior, in the back, killing her as she fell in a friend's arms.
Prosecutors presented surveillance and ballistics, proving Foy fired the fatal shot. His not guilty plea crumbled as China's family spoke of their loss. Foy flashed smiles, then laughed outright, enraging the gallery.
Foy, on May 3rd, 2021, you are a co-defendant.
Excuse me a second. Let the record reflect that the defendant is laughing during the victim impact statement.
Catch the full episode on the link above. Subscribe to Southern Sin today for more exclusive crime episodes. Every trial has a story the jury never hears, where the truth lives outside the courtroom. Join our host Dara Kennedy and the sharpest legal minds in the business for a new riveting show, Reasonable Doubt, What the Jury Doesn't Hear. No grandstanding, no spin, Just the arguments that could change everything. Tonight, one question dominates the Rob Reiner murder case. What made powerhouse attorney Alan Jackson walk away? And can a public defender really carry a death penalty case? Emotions explode in the Uvalde school shooting trial against Officer Adrian Gonzalez. And shocking questions surface in the YNW double homicide retrial. Was there witness tampering? All of it is breaking on at Southern Sin. Welcome to all our new followers from our sister channel at Truth Talks Live. You're watching at Southern Sin, your home for true crime. Hop over and hit that subscribe button.
Mr. Cruz and Mr. Hill. I don't know if Mr. Bolden has been with us in a charge conference or not, but Mr. Bolden as well. I just can't remember. And go through page 1 by myself. What Ms. Ellis has done, of course, is consolidate everybody's charges. And it will, of course, eventually be a document that doesn't have the titles of the charges. Obviously, it'll read like just a regular document, but for our purposes, the titles will be in there. So if you all take a look at page 1, I'm going to look through the indictment and make sure it mimics the indictment exactly. But if you see any, this is the time, the first couple of pages, to see if there are any typos. That's, just make sure we follow. And if there's a typo in the indictment, it goes into the charges as the indictment reads. We don't obviously correct anything. I don't know if there is. I'm just saying that's how we do it. So if you'll take a look at page 1 and let me know if there are any objections to page 1. All right.
No objections to page 1 from the defense.
All right. Very good. Let's do the same, obviously, with page 2. All right. You can certainly go on to page 3 and go through the indictment part of it. And just let me know what you, but I'll wait to, of course, hear from both sides.
appears to be a typo on page 3.
Okay. Well, let me hear from this defense about page 2, and then we'll go to page 3. No, I mean, you can continue looking. I want to go in order in terms of any objections. I'll wait to hear from Mr. Cruz. There's no. Okay. Okay. Already has a.
So, in said accused in the county of Clark and state of Georgia did perform a sex act with the person of Tara Baker involving the sex organ of and
What?
ate in front of.
Okay. All right.
Then at the bottom of page 3, after Edrick Faust, the word with the offensive rape.
Right. See it? Thank you. Anything else with regard to page 3? All right. Mr. Hill, Mr. Cruz, are you okay with page 3 after the correction? And the word with. Okay, we'll go on page 4.
Top of page 4, the second line, it says January 2001 did have carnal knowledge of Tara Baker. However, in the indictment, I'm mixing them up. Please forgive me. I'm mixing
Okay.
Disregard that.
Okay. Page 4, Mr. Bolden, anything from the state about page 4?
No, Your Honor, and I've just gone all the way to
Okay.
the bottom of page 5 to get through.
Okay. Okay.
I'm still on page 4.
That's fine. Absolutely fine. I just want you all to know page 6, in the very top, there's a typo. It needs to be his instead of her, but we'll get there. Those are the easy things to correct.
No issues with count 4, Your Honor.
All right, page 4. We'll go to page 5.
All right, one issue in count 12 of page 5. Just the word on is missing. Word on or about the 19th day of January 2001.
All right, let me just make sure that's what the. Okay, that's exactly right. Let's see. On, we're going to put an on before the or.
Also, count 12, the last line of count 12, well, the third line from last count 12, where it says laws of said state, the good order, and peach instead of peace.
You got it. Peach does not fit. Okay, excellent. Thank you. When you get to page 6, the very top should be his as opposed to her. So that's the first thing we need to change. When you're ready, if you all go through page 6, let me know what your position. Okay, I just want to remind you all, Ms. Ellis made a good point. Everybody's requests are in this document. We haven't taken anything out, state and defendant. So it's a big document. Obviously, we'll figure out how to pare it down properly, but just so you know, everything you've submitted is in here. Yeah, sure. Yep.
The bottom of page 5, just the hyphen in between not guilty.
Well, we typically have it in there. I'm not sure why we do, but if you would like us to take it out, we certainly can. All right, we'll do that. I think it just reads better, but we certainly can take it out.
in the second paragraph of page 6,
Yes.
the fourth line, where it says defendant is guilty of the offense charge, or just change it to offenses.
I have to figure out where you are. Hang on just a moment.
Second full paragraph. Well, the first full paragraph. First full paragraph. In the fourth line.
Well, I think we always have it as crime, just because I think it indicates that they have to individually apply this reasoning to every single charge. And so I see what you're saying, but I think we're going to leave it in there just because I don't want them to misconstrue that they have a responsibility that's not individual to each charge. Yep.
Where it says there is no burden of proof upon the defendant, the word whatsoever is missing. And that is the second full paragraph, third line.
All right. Let me look at the pattern. I've taken this from my standard jury instructions, and I'm not sure I have that word in there. So we'll look at the pattern for burden of proof and see what it says. Certainly want to follow the pattern. All right, this is the pattern.
That'll be the fourth paragraph of the pattern.
You're right. It says whatsoever. There's no burden of proof upon the defendant whatsoever.
While you have that pattern, Judge, is also missing
Okay.
language of that same line. And the burden never shifts to the defendant to prove.
Well, it says to prove innocence in the pattern. We have the word his, but we can take his out.
Well, no, that's not.
Okay.
It says, and the burden never shifts to the defendant to introduce evidence or to prove innocence.
All right. Mr. Bolden, any objection to increasing the language of the pattern charge and putting in introduce evidence and what? Introduce evidence or to prove innocence?
That is what the pattern says.
Okay.
Your Honor. Mr. Cruz wants that.
Yeah, no, I agree. And I think I'm going to change my patterns in the future to reflect that, since the pattern says that. They do change a lot of these patterns kind of every 6 months. And it may be that has been changed and I didn't realize it. So we're going to add this to paragraph 2. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove his innocence. And I'm going to keep the word his in there unless you don't want me to, Mr. Cruz. All right.
Can we copy the pattern language when we get into the definition of reasonable doubt?
Tell me what you mean.
Verbatim?
Hang on one second. I just need to send this message to another attorney about a case for Monday. So hang on just a moment. Okay, go ahead, Mr. Cruz.
Pattern language, and it's not a big.
Tell me where you are. Tell me.
I am on the 5th paragraph of the pattern charge, starting with sentence 2.
On what page?
Page 6 of the.
Okay, hold on. All right, you're asking about the reasonable doubt pattern?
And page 6 is the last paragraph. So the pattern charge. I apologize. The pattern charge states a reasonable doubt means just what it says. I believe that matches. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. And I believe Your Honor has the pattern charge up. Yeah, can we just use the exact language of the pattern charge?
Well, we have all of this in here. I guess, is it just because it's in a different order?
Yes, ma'am.
We need to start with the burden of proof. Well, we have, I mean, it is in here exactly the same. It's just in different paragraphs. I think
So
it is exactly the same.
okay. So
It's the pattern as written is reflected in the charges. I think maybe the difference is the statement, however, the state is not required to prove the guilt of the accused beyond all doubt or true mathematical certainty is in the paragraph above it.
no, that's fine.
We can move that to the paragraph below as it is in the pattern, but the order in which those phrases are, or those sentences are done is exactly here. It's this. I think it just looks different, but I can move that sentence, however, to the next paragraph if you'd like.
So the difference I have in mind is the pattern charge, and I think generally it says the same thing, but we're really big on language, and I'm very careful on language. In closing, it says it is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. And it says essentially the same thing, but the pattern charge says a reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth.
Repeat the words a reasonable doubt. Yep. I think that makes sense.
And I ask this, if it's not too much, can we just copy and paste that paragraph from the pattern charge and stick it into the charges?
Well, it is the same, with the exception of what you just presented, and the fact that however, the state is not required is actually part of that paragraph in the pattern. In our documents, it's part of the paragraph above it.
That's no issue. That's no issue.
But the rest of it, I think, is exactly the same, except for the words "a reasonable doubt," mentioning it again, which I will do. But I want to just make sure that put down again a reasonable doubt on the second line. so this is how it's going to read, and this is what the pattern says. However, the state is not required to prove the guilt of the accused beyond all doubt or to mathematical certainty. We can put that down to the next paragraph and just make it one paragraph. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt, and the rest of it is the same. Does that satisfy you, Mr. Cruz?
Yes, ma'am.
Okay, that's exactly what the pattern says. All right, and anything else on page 6?
I'm on the last.
Golden, if you want to jump in there while we're having this conversation, obviously do that.
Of course, Your Honor. State has no position.
Okay, all right. Okay, yep. When you're ready to go to page 7 and let me know what you think about page 7.
I included grave suspicion of guilt.
I'm sorry? Yeah, we haven't gotten there yet.
Okay, got you.
Yep. What you all are reading that goes through top of page 10 are the standard patterns that all superior courts here at least have in their arsenal. And obviously these are ones you all have asked for, but it's our standard ones. And so we haven't gotten to the specific ones you've. Yep. Yeah. So everything you all have asked for, we haven't kind of gotten to that yet. I mean, the specifics.
Yes, ma'am. All right. With the jury instruction, jury judges of law and fact.
Which page are you on, Mr. Cruz?
7.
Okay.
Just the last sentence says, it then becomes your duty and responsibility to apply the law that I give you in this charge to the facts as you find the facts. Okay. It's nothing that needs to be changed. Attention.
Michelle's this morning did not yet. It makes Monday easier. All right, are you all still on page 7, or we moved on to page 8?
I am, Your Honor. I'm looking.
Okay. Mr. Bolden, are you still on page 7? Okay. You okay with page 7?
Yes.
Okay. Nope, that's fine.
Welcome to all our new followers from our sister channel at Truth Talks Live. You're watching at Southern Sin, your home for true crime. Hop over and hit that subscribe button. You're watching at Southern Sin, your new home for true crime. Smash that like button now. We'll be right back.
We'll move to page 8.
Hit us in the chat if you think the defendant is guilty or not guilty.
What's the site? The site for evidence is the means by which any facts which are put into issue is established or disproved. Do you know the site for that one?
You mean the pattern number?
Yes, ma'am.
Well, it's really hard to look them up.
I think I just found it. I think it's 1.3010. I think I just found
Got
it.
it right here. Yes, what about it, Mr. Chris?
Is that it? No, I just wanted to find it. That was it.
Okay.
Just to match it up.
The instructions that we have, that we use, don't make it easy to like search and do it in order. That doesn't make it easy to put this policy across.
Does read that evidence includes all of the testimony of the witnesses, parenthetical, and any exhibits submitted during the trial. And then the next parenthetical says stipulations of the attorneys, which I think would be applicable here because we do have the one stipulation as to the photo of Mr. Faust that was so the photo was entered into evidence, but then the stipulation was also that it was a photo taken of him on, I think it was February 8th of 2001. Mr. Yalamanchili put that on the record at the time that the photo was tendered.
Okay, so you're saying this is the pattern. Evidence includes all of the testimony of the witnesses, and then parentheses, which I don't think is applicable.
Correct.
The equivalent, such as depositions, so we'll leave that out. And any exhibits admitted during the trial, stipulations the attorney said is any, okay, so do you, I could, well, and I'll hear from you, Mr. Cruz, I could just do it this way. With all the testimony of the witnesses and any exhibits admitting during the trial and any stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, period.
That would be how the state would ask that the court.
Mr. Cruz, how do you feel about?
I have no objection to that,
Okay,
Your Honor.
so we'll do it that way. Oh, no, okay, hold on. I have your computer. How could you have gotten? All right, so what we'll do is input the word and any stipulations of the attorneys, put that all in there, and then not matters of which
And then I would also say, I don't know if this was in the requests that I made this morning, and if not, I apologize, but I think that does make the next one in the pattern, which is 1.30.12 applicable, which is the pattern on stipulations.
All right, we're going to look it up in just a minute.
I apologize.
Well, I mean, this is what this is for.
Sure.
We have to, you can also make oral motions for certain charges. I mean, that's obviously why we're here. So let me let her finish 1.30.10 and then might have added to this case specific one. So if it is added in, we should put it there. That would make sense.
Yes. I apologize.
It was? It was not. It was not. Okay, so I think, okay. 1 point, okay, so Mr. Cruz, in case you don't have it in front of you, 1.30.12 says, okay, I was trying to figure out where it was. So there are several, let's all look at 1.30.12. There are several things that could be I'm just going to throw out what I think, and then I'm going to listen to what both of you want to add. There's only been one stipulation, and I think making providing all this emphasis would be very confusing to the jury. This would be my sense, but I'll hear from both of you, to just put in there, the parties have entered into a stipulation that has been approved by the court about however we decide it is about the picture, and leave it at that. The rest of the statute is pretty convoluted about probably convoluted stipulations. And so that would be sort of my.
And that would also be the state's position and request, Your Honor. So again, under that pattern charge, 1.30.12, just that the parties have entered into a stipulation that has been approved by the court about the following exhibit, whatever exhibit number that would be, and then that was a photograph taken of the defendant on February the 8th of 2001.
I think you both have to come up with the language that suits you both. Before we get into that.
Sure, I apologize.
Sure. No, I mean, you don't I have to apologize. I mean, I just think we need to talk about what the language is. Mr. Cruz, without getting into what language is the exhibit that's been that describes the exhibit that's been stipulated to, do you have any objection to 130.12, which is the parties have entered into a stipulation that has been approved by the court about the following, about the following exhibit?
I do not.
Okay, so let's talk about, so we'll put that in there. Let's talk about how to phrase it. Let me get us you say again, Mr. Bolden, what you think it should say?
Yes, Your Honor, I would say that, so the parties have entered into a stipulation that has been approved by the court about the following exhibit. And then in the pattern where it says specify, I would suggest something to the effect of that state's exhibit, whatever the number is, and I'll find that out momentarily, was a photograph of the defendant as he existed on February the 8th, 2001.
Okay. Cruz, thoughts on that language?
That's what we agreed to.
That's what I thought. So I hope.
Are you satisfied with that, Mr. Cruz? Okay. Will you say it slowly so Ms. Ellis can take that in?
I will. I probably won't be able to do it exactly the same way, but I will try. That state's exhibit blank, which I can fill in due course, is a photograph of the defendant as he existed on February 8th, 2001.
Okay. I have 113. I have that as a stipulation, but I didn't label in my notes what the stipulation was. So we need to double check and make sure it's 113. We can do that when we're finished, but let's make sure we actually get that in there. Okay. Let's keep going on page 8. Okay. I'm going to read this to you all since Ms. Ellis has just redone what you have said. The parties have entered into a stipulation that has been approved by the court about the following state's exhibit 113 about, I think we should just say about state's exhibit 113. I'm going to just say about the state's exhibit 113, unless you all have, it just sounds better. About state's exhibit 113, colon, a photograph of defendant as he existed on February 8th, 2001, where parties stipulate, let's see. Where parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Where parties stipulate exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. That is the pattern. Mr. Bolden, I'll ask you first. Any thoughts on all of that?
That's acceptable to
Okay.
say, Your Honor.
Mr.
Thank
Cruz? All right, we'll move on to page 9.
Your Honor, on page 9, at the very, not at the very bottom, but towards the bottom, to impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. I see that that's the 1.31.45. I guess the state's concern here is I am not certain that anything has been disproven as to what they testified to. I understand that the defense would maybe disagree with whether or not their credibility, and that's a separate instruction. So the kind of that particular pattern gives an either or. The first part says impeaching a witness is to show that the witness is unworthy of belief. Then there's the or. The credibility of a witness may be attacked by disproving the facts to which the witness testified. I mean, it's my position, it's the state's position that second part would actually be more tailored to this case.
The whole okay, so you want to go to page 21.
My page.
Okay, hold on. Let's fast forward to the defense number 11. Let's go to defense number 11 and look at the whole pattern in total, and then we'll discuss it. Since what we did was we included everybody's requests and didn't take them out, even if they touched on something ahead of time. So on page 21 in the middle is defense request 11, which is the pattern. All right, Mr. Cruz, do you care to be heard? Which of those portions of the pattern you think we need to have?
I believe the first one. I think a big, well, 21 is large. So let me start there. Well, where are we starting on page 21?
It's the one right in the middle, 131.45.
Okay.
You're 11.
So I would say to impeach a witness is to show what Mr. Bowden read into the record.
Yep.
Witnesses impeached each other during this trial. We use certain witnesses to impeach other witnesses. I think a big one that sticks out vividly is, I believe Ricketts was extremely adamant that Chris Melton's alibi had been confirmed. And we went through with other witnesses establishing that it had not, in fact, been confirmed. And I think a big part of our cross was locking Ricketts deeper and deeper into his statement that we confirmed it. And I even think a little bit with Ricketts, we started going with him through some of the places that were unconfirmed that he ended up admitting. So and that's just one example here. And I think a second example was Mr. Melton, who refused to acknowledge that he was living in his parents' basement at the time. And obviously because we showed him the photos with the doors showing how he could get out. However, Josh McCourty was the witness that came in right behind him and said, oh, Chris was staying in his parents' basement. So we would ask for that instruction. We intended to use it in closing.
How would you both feel if the court included both of them in the manner in which it is in the pattern, which is disproving the facts to which the witness testified, or let's see. I don't know, including both of them. I'll have to think about how to do that.
I don't have any objection to including both.
I don't want it to be confusing, but Mr. Bolden.
I mean, I guess it gives, but my point is still that I don't know that that's actually disproving anything that another witness testified to. I understand Mr. Cruz's position, but I think Agent Ricketts' opinion that Mr. Melton's alibi was confirmed is like that's getting into kind of a subjective nature of his assessment of the alibi, and you can't disprove something that is a subjective belief in someone's mind. If it was an objective fact, I think that's really more what the impeachment statute and the impeachment pattern is designed to cover. again, I think that it will all be covered in, credibility and stuff like that. And that's the only reason I bring that up.
Well, I'm not going to make any comment on the evidence.
Sure.
The strength of the evidence. That's for the jury to decide if they choose to about these particular moments we've been discussing. So I think it would be appropriate to include the entire pattern as written. And I think I'm going to do that. I'm going to grant your request, Mr. Cruz, and let's see, I think we need to put it, defense's request 11 in, on page 9.
Question for you. On the bottom of page 9, your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony. Where is that located? The pattern number.
I don't know exactly. I mean, those are our standard charges that we have from pattern. And I always read those, and I'm going to continue to read those. But I will find the pattern for you. But let's just jump on top.
I see that one.
Yeah, let's jump to the impeachment first and get that squared away.
Yes, ma'am.
So we're going to keep in defense is 11, and it's going to read, let's see, exactly how it is. It's going to read exactly how it is. As you've requested, it's already in the instructions. But let's talk about credibility of witness. Let's see. I'm just going to put in there, and I'm doing this over objection by the state. This is how it's going to read. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. The credibility of a witness may be attacked by disproving the facts to which the witness testified. I'm just going to put both of them in there. I know the pattern says or. I don't think it'll be confusing. I don't want to comment on the evidence. I'm just going to put the whole thing in there. So we'll put it in that area on page 9 where it starts with to impeach a witness. Does that make sense? Okay. All right, let's go to then the next paragraph. You had a question about that, Mr. Cruz?
I did not. I found it. I was just trying to match it up.
Anything else about page 9 from the state of the defense?
No, ma'am.
Let's go to page 10. And then page 10, right after the very first paragraph, is where we start to put in the requested charges. Yes, and sorry, Ms. Ellis wanted me to make sure everyone knows, we obviously pull the titles out. I don't put the pattern number in there. I don't know if some courts do that, but we don't. It just reads like a document. The whole thing reads smoothly like a document.
Yes, ma'am.
And Mr. Bolden, I wanted to ask you on page 10, after 1, 2, and 3, where there are 3 phrases in parentheses, are you asking for all 3 phrases to be in there?
I'm sorry, can you say that one more time?
Yeah, well, you have to be looking at the page to understand what I'm saying. It didn't make sense. Sorry.
No, that's all right.
Okay, so after 2, 10, 10,
Yes.
we put in your request 1, defense's request 35. Oh, I should ask you this too, Mr. Cruz. I actually just saw that it was also your request. All right, both counsel. With regard to 2, 10, 10, after where it says for malice murder, the state must prove the defendant 1, 2, and 3. The next paragraph, at the end of that paragraph, has 3 parentheses. Without justification, another one without excuse, another one without mitigation. I'm asking both counsel, do you want all 3 parentheses in there?
We can. I don't think it's applicable to this case. I think we may have filed a motion, I believe, letting the jury know that identity is the issue. We may even say it in closing that the sole issue is identity. But it's up to the honorable court. I have no position whether the honorable court includes it or. Well, I guess it does, Nick, because it is the law. I think that is in the statute, if I'm not mistaken. So, yeah, I think it would need to be included unless a particular one applies. And in this case, no one's arguing a particular one applies.
Yes, and I would ask that there be a period after the word kill. I'm not asking for any of the parentheticals. I don't think any of them are applicable.
So you're just asking rather it is the unlawful intent to kill, period, without the parentheticals. That's what you're saying?
Yes.
Okay. Mr. Cruz, any objection to that?
For purposes of the record, I would say yes. I would just say to keep it with the statutory language. I don't disagree with Mr. Bolden in substance, but I do have to be aware of the appellate record here. So I would say without justification, without excuse, without mitigation, but I'll leave it to the honorable court's discretion.
I think I'm gonna take it out, and the reason I'm gonna do it is this: there hasn't been any evidence regarding justification, excuse, or mitigation, and so I think it would be confusing to the jury, and obviously that's one of the most important things to look at when you're dealing with charges. It also doesn't fit the evidence, and so I'm just gonna put a period after the word kill. All right. And then the next two paragraphs is part of that pattern, of course. You both have asked for it, but if there's something you're thinking about you want differently, let me know.
And the honorable court's ruling is supported by the pattern charge. It says charge only the appropriate language, adapt parentheticals to the indictment and the evidence.
Your Honor, I've moved on to page 11.
As well.
All right, very good.
So I don't have any issue with premeditation, which we both requested. As far as motive goes, I mean, I requested and we just copied straight from the pattern. State does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining if the defendant's state of mind at the time of the killing. State hasn't offered any evidence of motive, so I don't know that the second sentence is applicable here.
Let's talk about, before we do that, the 21011 that you both asked for, premeditation. Any objection to how it's written in the charges?
And I'm matching it up there. If you give me 30 seconds, Your Honor.
Sure. Oh, you're off. Okay. Say the number, 21011. Okay, we're on 21011. Premeditation.
And what's the state objection to premeditation?
Objection was to the next.
I have none to premeditation.
We're going to start. We'll kind of go chart.
One at a time. I got you.
So motive?
So we're on premeditation, the 21011. Do you have any objection? You both requested it. Any objection to how it's written?
No, ma'am.
Okay, so we'll move on then to 21012, motive. The state has, you've both requested it. The state has asked to get rid of the second sentence. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Okay, any comment on that, Mr. Cruz?
Well, I intended to use motive in our closing. And that sentence, although it says defendant, I was going to switch it to fit our evidence in this case. I would ask that it's included if any change is made. Defendant is fine with me, but if the honorable court wants to make any change, just defendant is fine. Defendant is fine with me.
I'm not making any comment on your closing at all, but I am going to get rid of that sentence because I don't think it fits the evidence with regard to the state's position of evidence of motive for the defendant.
Yes, ma'am.
But certainly you've made it clear you've talked about motive for other things, and you're certainly not prohibited from talking about that in your closing. So that it'll just read 21012 will read the state does not have to prove motive to prove murder. All right. The next one that you have both requested is felony murder. And we need to talk about how to articulate that. There are 4 counts, I believe, of that in the indictment. Count 2, 3, 4, and 5. So let's just talk about 21020. Any objection to how it is written? It's obviously the problem.
No, not how it's written, Your Honor.
I'm sorry?
No.
Okay. Mr. Bolden, any objection to how it's written?
No, Your Honor.
All right. Let's talk about how to talk about blank as a felony, which I will define for you shortly. Yes. We're going to take the parentheses off where it says the state does not have to show that the defendant acted with malice to prove felony murder. Just leave it as a sentence. The next one is blank as a felony, which I will define for you shortly.
Can we? Oh, I'm sorry.
Yeah, go ahead. No, go ahead.
In regards to that, can we state all? I think it's 4 felonies. Can we state all 4 felonies? So, rape, just state them back to back, and then when we move to 21030, we can say the same thing with the first blank with all of them, regardless of whether he or she. And then when we get into the definitions, if the state doesn't disagree, just to keep it from being confusing, we discuss each charge just back to back to back. So that way we note all 4 felony murders, we note all 4 underlying charges, and then we also note or give the definitions following. So we at least signal to the jury, there's 4, and here are the 4 in the definition of the 4. And it may kill 2 birds with one stone because it also gives them the definition of the underlying crimes as well that we're charged with.
I think there may be some agreement, Judge.
Tell me what you mean. I mean, whatever way it needs to read where it doesn't confuse people is fine with me. I just want to.
What in the way that I submitted it in the state's requests is where there's the blank at the bottom of page 11 would just be burglary, aggravated sodomy, rape, and aggravated assault are felonies.
Okay.
Which I will define for you shortly. I think that's what Mr. Cruz is saying is well done.
Is that what you're saying? Just all in one are felonies, which I will define for you shortly. Okay. Okay, so it's burglary. Do you want it to say burglary to a dwelling or just burglary?
Burglary would be.
The indictment says burglary to a dwelling.
So we'll use the indictment language.
All right. So we'll do burglary to a dwelling, comma, and we're on 21020. Burglary to a dwelling, comma, aggravated sodomy, comma, rape, comma, and aggravated assault are felonies, which I will define for you shortly. Counsel, are we in agreement on that?
Yes, Your Honor.
Okay. Let's go to the next. Yeah, of course. You're the one doing this.
In the very beginning,
Mhm.
the grand jury has indicted a defendant with malice, murder, felony, or felony. I had just written burglary, so I put burglary to a dwelling.
Well, I guess the difference is that count 2 says burglary to a dwelling in reference to felony murder, but the count 6 says the offense of burglary. So I think it probably reads, that's accurate. Yeah. Okay. Let's do 21030, causation in felony murder. Both parties have requested this one, and it goes from 11 to 12.
I have no objections to that one, Your Honor.
And so again, kind of just like a minute ago, I think what the state would request is that you may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of burglary, aggravated sodomy, burglary to a dwelling, aggravated sodomy, rape, or aggravated assault. Kind of to track the language that we just talked about.
Any objection to the way that that's been articulated, Mr. Cruz?
No, ma'am.
Okay, we'll use the word or, regardless of whether he, not she. Okay. Any other comments about the top of page 12, which for our purposes is 210:30? Any more comments on that?
No, Your Honor.
Okay, Mr. Cruz, are you satisfied with 210:30?
Yes, ma'am.
Okay, let's go to 26221, burglary in the first degree. Both parties have requested it. Mr. Bolton, let me ask you first, since it's your burden. Number one, did you want both entered and remained in?
I was just looking at that, Your Honor. I think that's the way. I would ask that it have both entered and remained in, because those are both included in the charging language of count 6.
I would have, because you all's theory, I guess, that he entered the house.
Okay, it does, count 6 does say enter into and remain. That does track the indictment. I think it needs to say entered into and remained to track the language of the indictment. Mr. Cruz, do you have any objection to that change on the number 1? Okay, so we'll do that and get rid of the parentheses. Do you have that? We good? Okay. The intent to commit a felony. All right, let's go to count 2. And then we put in here well, okay. Mr. Bolden, what are you asking the court to put in the blank?
In the blank, I would say aggravated sodomy and rape are felonies, which I will define for you shortly, because those are the specific felonies that are referenced in count 6.
Okay. Any objection to that language?
No, ma'am.
Okay. Let's go to the bottom of that pattern that you both have requested, and let me know what you think.
Well, I guess we'll wait till we get to it.
I'm good through the bottom of page 12.
I am too.
Okay. All right. So we're going to start on the next one. I'm going to just make sure Ms. Ellis can follow with us. It's 26223, intent to commit a felony. All right. This is state's request 7.
Yes, Your Honor.
All right. What is your request?
Your Honor, bear with me just a second.
Okay. Okay. All right.
And on our copies that you provide us, it will have the title on our copies. Oh, it won't have any title.
No, this is the only version where you'll have the titles. So what we're going to do is Ms. Ellis is the master at all this. She's taking down all of our changes. She's going to incorporate it in the master document and delete, of course, all of the titles. And then what I do is I make a copy for every juror and every attorney and Mr. Faust. So everybody will have their own copy, and it'll be the same that the jury is holding.
Okay.
I would, Your Honor, I think I would withdraw state's request number 7.
Okay. We're going to withdraw 26223. Yes. Okay. All right. We could email it to all of you when we're finished. Sure. All right. So let's We'll get rid of that. All right, 26231, this is state's request 8.
We would ask that that be given.
All right, we're going to have to,
But I would, my suggestion as it relates to state's request number 8, 26231, would be to move that to until after the court defines burglary, which I think is later.
let me just do this. We just defined burglary in
Okay, I'm sorry. Okay, I'm sorry.
Yep.
Yes.
Okay, so I guess my question is, how did you want 1, 2, and 3 of your request to read before we get to Mr. Cruz's response? Or do you want it to read like that?
I would say just number 1 would be the most
All right.
narrowly tailored to the case.
Okay. Mr. Cruz, any objection to 26231 reading? To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This quote, breaking of the plane, end quote, must be done by the defendant. Any objection to that charge?
No, that's the pattern language.
Yep, it is. Okay, and we'll cross out 2 and 3. And we're going to cross out the number 1. We're just going to put in must be done by the defendant. Okay. The state does not have to show that there was an actual break-in to prove burglary.
Hold on, say that. What are we doing now?
So we're on 26231. So on your copy, it's the middle of page 13.
Mm-hmm.
And what the state has requested is this. To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This quote, breaking of the plane, end quote, must be done by the defendant. The state does not have to show there was an actual break-in to prove burglary. That's the request.
I understood. So we're taking out 2 and 3.
Yes.
Would the court consider giving the kind of not the parenthetical, the example that is given in the pattern? I'm kidding. I'm sorry. So about breaking the plane, football breaking the plane. I'm not requesting that. I'm sorry. I'm just kidding.
I'm not looking at the pattern. I'm looking at it.
Sorry.
All right. Any further objection, Mr. Cruz, or any comment?
Not at this moment, Your Honor.
All right, 23010, which is requested by both counsel. And of course, we're going into page 14. It'll be a different page, obviously, when we're finished. Mr. Bolden, any other changes to that request from the state?
No, Your Honor.
All right, Mr. Cruz, your request is 41. Any changes to your request?
No, ma'am.
All right, so it will be given as requested by both parties. We'll go to the next page, towards the bottom of page 14 for us. It's 23210 for Ms. Ellis. This has been requested by both parties. I'll ask Mr. Bolden first, any changes about how you want this charge to be? I mean, this is the pattern,
So, I mean, this is where it gets a little confusing because there are the 2 different aggravated sodomy counts. I don't know if the court's preference would be to charge separately on each of those counts, or if the court thinks giving the definition of the crime once and then kind of incorporating, as alleged in count, bear with me.
Okay.
As alleged in count 7 to include the sex organ of the accused and the mouth of the victim. And then in count 10, the sex organ of the accused and the anus of the victim, or if you just want to define it twice. Does that make sense what I'm trying to get at?
yes, it does.
I mean, I don't know which way is less confusing. So I think that's why we requested it be given twice. I think that might be the easiest way. So, for state's request 10, for aggravated sodomy as alleged in count 7, the state must prove that the defendant and then I'm looking at the top of page 15, only use mouth, and then give the rest. And then I realize I'm jumping ahead here, but then for state's request 11, that it read for aggravated sodomy as charged in count 10, the state must prove, and then use anus instead of mouth.
Okay, so you're asking some additional language, which is for aggravated sodomy as charged in count 7. That's what you're asking for. Count 7 of the indictment. The state must prove that the defendant, okay, and you want the word mouth, and then you want it read again in the same way as charged in count 10. Of the indictment. State must prove, and then the word anus. Okay. So you're asking then, with those additional words, to read it twice.
Yes, I think my personal opinion is that would be the least confusing way to explain.
Mr. Cruz, I'll hear from you about your thoughts. You had asked also for 23210. You had asked the same, you have the same request, but the state is the only one that asked for it twice, just given the 2 different counts in the indictment. So thoughts?
I'm fine with it twice.
Okay.
So I don't oppose that. I do have a question for you going back up to rape.
Hang on, just let me make sure Ms. Ellis got it. Go ahead.
All right. So, and if it's not appropriate now, I can add.
No, go ahead.
With the rape instruction, one of the elements is against her will. We did intend to argue that the state has to show that it's against her will, which I think is appropriate for their burden. I just want to make sure the honorable court is okay with that, where it doesn't violate anything.
Well, that is the state's burden, and that is the statute.
Yes, I think I understand what Mr. Cruz is asking, and I think that against her will is an element that the state is required to prove beyond a reasonable doubt.
Okay. Are you asking, Mr. Cruz, I want to make sure I understand what you're referring to. I mean, I do understand what you're referring to, but in the larger context of this trial and the motions that we've had and things of that nature, are you implying that because that is part of their burden, that you are going to argue anything about consent?
Absolutely not. Now, I will say this, Judge. I may disagree with your rulings, but I respect the court. I always have to respect the court.
And I wasn't insinuating you weren't. I'm just making sure I understand what you're saying.
But instead of arguing consent, we're just going to put the burden where it belongs, which is on the state. And we are going to argue that they do have to prove that it was against her will without consent.
All right. Thank you. Anything further? Okay.
Understood, Your
All
Honor.
right. And are we then finished with 23210? Let's go back to page 15. Anything else from the state on 23210?
No, Your Honor.
All right, Mr. Cruz, are we finished with 23210 or anything else we need to talk about?
Court's indulgence, Your Honor. It's But no, so we're going to do it twice, one for anus, one for oral?
That's correct.
Okay, let's go.
I mean, that's what you said you were fine with.
Correct.
Okay. All right. Let's go to the next page then. And to the state's request, 23015, and of course, then 23017. And the state has only requested these.
Yes, Your Honor. And what I would request is the way that what we submitted was a little bit more tailored, and I would just say that sexual battery, aggravated sexual battery not be included, that the state must prove that the alleged victim did not consent to sexual intercourse or aggravated sodomy.
Are you asking for the rest of it to be there too? If you find that the victim was not mentally or physically capable of consenting?
I don't I don't necessarily know that that is applicable here.
Let me ask Mr. Cruz about his position on state's request 12, which is 23015.
Court's indulgence, Your Honor. Yeah, I don't believe this applies to the facts of this case. Incapacity to consent. There's no.
Let's back up. I understood Mr. Bolden's comment that you are not asking for that language. Am I right about that? If you find the victim was not mentally or physically capable of consenting, you'll be authorized. Are you asking to take that out in your request? That's what I thought you meant.
Yeah, and
I agree with the first sentence, but just the following language, it doesn't fit the evidence in this case.
I would, the court doesn't want to get.
I'm not sure 23015 fits this case at all.
And I don't necessarily disagree, Your Honor. I think if the court were to incline not to give.
I agree. Yeah, I don't think it fits, but I think that first sentence is also in lack of consent.
Sure. Hang on just a minute. All right. Is there any objection to the court not giving 23015? All right, Mr. Cruz.
No objection to not giving 23015.
Okay, we're going to cross that out then, and then we're going to go to 23017.
I would withdraw that.
Can I look at the statute really quick, Your Honor? Not the statute, I'm sorry, the language.
I mean, the state is withdrawing it. If you wanted to request it, we can talk about it, but they're going to withdraw their request. But I'll certainly let you look at the statute and decide what you want to do.
Yeah, I believe 203017 fits the language because of the aggravated sodomy piece. And the particularly the oral charge of aggravated sodomy.
So tell me what you're asking, Mr. Cruz.
I'm asking for 203017 to be included in the charges.
Okay. Mr. Bolton, any comment?
I'll leave it up to the court.
Sorry?
Whatever the court thinks is appropriate.
All right, if you have no objection and the defense has asked for it, then I will leave it in. I was going to eliminate it based on our elimination of 23015, but if you all are basically in agreement, we will keep it in. And I think it just needs to read to the words of aggravated sodomy. I'll just take out the rest of it,
Agree with that.
obviously. Okay. Let's go to, did you get that? 230, 17? Okay. 230, I'm sorry, 220, 21. Both parties have requested this. I think number 2 needs to be deadly weapon, would fit the evidence.
Yes, that's the way that it's
All right.
indicted.
Let's see. Yes, it is indicted that way. So we'll cross out with an offensive weapon, put in with a deadly weapon. Okay, so with that change, both parties have requested it. Anything else, Mr. Cruz?
I'm matching up the language, Your Honor. Please forgive me.
Okay, that's all right. We'll go to page 17 also. In the top of page 17, we have to finish the pattern. I knew there had to be more to that pattern than just those 2 sentences. All right, when you're finished, go to the top of page 17 to finish discussing charge 22021.
And so at the top of page 17, Your Honor, I would ask that the sentence beginning with the word however read as follows. The state must prove that the defendant attempted to cause a violent injury to the person, period. And that second parenthetical not be included. I think that would be based on the way the charging language in the indictment. I think that would be the correct way the correct way for the court to charge the jury based on the way the state has brought that aggravated assault charge.
Okay. Any objection to what Mr. Bolden has just stated, Mr. Cruz?
No objection, Your Honor.
Let's talk about the next line, though, and make sure we're all comfortable with that. An offensive weapon is any object is likely to cause. That's okay. That looks right. Any objection to that last sentence? An offensive weapon.
No, I would ask that not be given. I think that's just probably part of the pattern that comes in if you use the object which when used offensively language. But since here the state has alleged a deadly weapon,
yeah,
I don't think that
makes sense. Right. Of course. Mr. Cruz, any objection to eliminating that line? An offensive weapon is any object, et cetera, et cetera.
No objection, Your Honor.
Cross that out. Let's go to 2-2023. Deadly weapon. And in deciding whether, let's see what this indictment says, a knife, deciding whether a knife is a deadly weapon. This is 2-2023.
Can we, I believe it's undisputed that the knife was a deadly weapon. If the honorable court wants and if the state is willing to agree to it, I am fine with an instruction if the court wants to tell the jury a knife is a deadly weapon. But I'll leave it up to the state and the honorable court.
You're agreeing to the statement, a knife is a deadly weapon.
Instead of this one, because I don't think either party disputes whether or not the knife was a deadly weapon.
Mr. Bolton, any comment on the offer by the defense?
I mean, I think that's perfectly fair.
Okay, so we'll just say, period, a knife is a deadly weapon.
Correct. I was going to say the parties have stipulated the knife is deadly weapon, but you can say it that way too. I think it gets the same message across, so we're fine with that.
Okay. Say that again. Sorry. Okay, so the next one, 16, okay, 26810, the state has asked for just A1, but the defense has asked for it too. What the defense asked for?
Let me read the statute, Your Honor. I'm trying to find it now.
part? Okay. Oh, I see. Okay. A1. So there, oh, so there's no pattern. Is there a pattern? Oh, there's no pattern in this. Got it. Okay. I'm sorry, I wasn't following you.
Under the pattern, it just says OCGA.
Got it. Okay. I think A1 is the only one that fits. But you let me know, Mr. Cruz, when you're ready.
Okay. I agree with A1, Your Honor.
I'm sorry?
I agree with A1.
Okay, all right, so we will.
I'm
give
sorry,
it-
I've gotten lost. Where are we?
We're on 26810 arson, but of course, it's just the statute.
Okay.
And the defense agrees that what the state has asked for, A, and then 1 is what's appropriate.
Well, oh, go ahead.
See. Yes, I think we should take out the letter A and the number 1. Sure, let me just read it again. He or she knowingly damages.
And if I could be heard,
Yes,
I think what the state would ask, if the pattern only says to look to the statute, and I think that's what I understand, then I think the state's request would be that this charge read, a person commits the offense of arson in the first degree when by means of fire, there's no evidence of explosive here, he knowingly damages any dwelling house of another without his or her consent, period.
I agree with that.
okay.
No
He,
objection to that.
okay, so he knowingly damages, I'm sorry, he knowingly damages,
And instead of he, can we use the defendant? Oh, I guess it's the same.
I think it's probably more appropriate to say he as opposed to defendant. Yeah, I think more general in nature makes more sense. By means of fire, he knowingly damages any dwelling or house of another without
His or her consent.
his or her consent,
Period.
period. Okay, and Mr. Cruz, you don't have an objection to that?
I do not.
Okay, so that's how we'll give it. Let's do the next one, arson, presumption of accidental cause, state's request 17, 26816. Let's see what the damage by means of fire is what's in the indictment. Damage by fire, so we're going to cross out the word burned just for starters. And I think we cross out or as a party to it. There's no evidence about that.
Yes.
Thank you.
All right, Mr. Bolden, anything further we need to change from your request before I ask Mr. Cruz?
No, I think it's an appropriate statement of the law, especially when arson is charged, that they're all presumed accidental. So,
Mr. Cruz, any objection to the state's request 17, which it would read, the burden rests upon the state to prove beyond a reasonable doubt that the building described in the indictment was damaged by fire. Number 1, the building in the indictment was damaged by fire. 2, the burning was caused by a criminal act. And 3, the accused was the person doing the burning. Any objection to that?
No.
Okay, and then the paragraph below that about the law presumes every fire to be accidental or naturally caused until the state shall prove beyond a reasonable doubt that such fire is the result, etc. Any objection to that language?
No, ma'am.
Okay, we'll give it as requested with the changes that we just made. All right, let's look at 24040. State and defense have both requested this one. Let's see. We'll put on his person as opposed to his, her, or within arm's reach of his person. We can talk about what you all want. All right, let me ask the state first, since and then I'll ask the defense what you want. Mr. Bolden, what do you think 24040 should read?
Yes, Your Honor. I think that it should read that for the possession of a knife during the commission of a felony, the state must prove that the defendant had a knife with a blade at least 3 inches long on his person while committing malice murder. Because that's the way that
Okay, that's
it
indicted.
is indicted. Which is a crime involving another person.
Which is not which is one of the following, which is a crime against another person.
Yes, Your Honor.
Okay. Mr. Cruz, any comment on how the state has asked for that charge to be given?
None of that matter, Your Honor.
Okay. So it'll read this way. For 24040, it'll read this way. For possession of a knife during the commission of a felony, the state must prove that the defendant, 1, had a knife, 2, with a blade at least 3 inches long, 3, on his person, 4, while committing malice murder, a felony, which is a crime against another person.
Yes.
Anything? State satisfied? Is the defense satisfied with that?
Yes, ma'am.
All right, thank you. Let's go then to the next page. We'll cross out the controlled substance, obviously, information at the bottom. 130, 130. Both parties have requested this. Mr. Bolden, what part of 130, 130 are you asking for? I'm not inclined to put in the 11th Circuit information. I mean, I'm inclined to just stick with the statute. I mean, the statute, the pattern. But I'll hear from both of you about including the extra language. I think the extra language is taken care of in the pattern.
Yeah, I would agree with the court to give that the first 2 paragraphs and then not the pattern jury charge from the 11th Circuit. I have no problem with that, Your Honor.
Mr. Cruz?
I believe it's the same, so.
Okay. All right, I'll cross out the 11th Circuit opining because it's really taken care of in 130, 130. Okay, 130, 140. And this was requested by both parties.
So can I go through this one with you, Your Honor? Kind of save the court some time. So I don't think anything came out for character and truthfulness. I was on cross, so I didn't bring in any reputation, evidence of opinion or other witnesses regarding a person's character for untruthfulness, bias towards a party. Now, I believe I elicited it, but I will at least say I attempt to elicit it through Detective Ricketts when I asked him specifically, why are you defending Chris Melton? And the purpose of that question was to support that charge on it.
All right, so let's do this in pieces.
Okay.
You are offering that the component of 130, 140 that applies to character for untruthfulness is not applicable.
Correct. That is not applicable.
Let me ask Mr. Bolden, any comment on that?
I don't believe there's any character for untruthfulness.
I agree with both of you. Okay. Mr. Cruz has made an argument to keep in bias toward a party. We got to read how to do that. In general, do you have a comment on Mr. Cruz's request?
And I'll pull up the statute just in case.
There's nothing about criminal convictions. We're going to get rid of that.
So I guess my position as to bias is I don't think that this is the pattern charge that would relate towards bias in the way that has been shown in this trial. I think it would go to the credibility, the general credibility charge, which I can't even remember at this point if we've discussed or if we will discuss, but that charge has the language about how they may consider their, manner in testifying, the facts about which they testified, and any bias. And I'm paraphrasing because I can't think of it right this second, but that would be.
And I could fully flesh out that argument, John, in regards to bias. I think that was just one component of it. A bigger piece of it was once the investigation started in regards to Mr. Faust and our examination with Ms. Bigham, and the larger piece of that argument, without going into all the other components, the larger piece of that argument was, if I can remember the statement, and I'll paraphrase the statement, when we had the discussion during the examination regarding the statements made to Chris Melton regarding the actions he should take moving forward. So I do believe we brought in different pieces of evidence through testimony supporting that charge.
Okay.
And the state is the party, just to make it clear,
I understand what you're saying. I want to just see if we've kind of given it in another way.
Sure. And
the statute. Yeah, go ahead.
What I was referring to is 1.31.10, where it says that credibility of witnesses, the jury may.
I keep doing that today. All right, hold on. We only have one computer. Let me pull up 131.10 before we get started. And I don't want to lose what Ms. Ellis is doing on the computer. But all right, go ahead, Mr. Bolden.
Yes, Your Honor. So that again, like I think we've already gone over that particular charge, but if not, I know that we will. But
it's in the beginning of the charge. We have gone over it.
And so the jury will have been charged on, general credibility, and part of that is their interest or lack of interest in the case. So I think that's the type of. I think that's what Mr. Cruz is getting at. I don't think that bias towards a party shown by bad acts, being specific instances of the conduct of the witness, which is in 131.40, is what is contemplated here. So I would ask that it not be given. I know that was part of our requests, but that was anticipating what some of the potential evidence today may have been.
All right, thank you. Mr. Cruz, anything further?
I would just stand by my argument, but I'll leave it to honorable court's discretion.
So I think I agree with the state in terms of this particular pattern, and I don't disagree with your assessment that the issues concerning whether you want to call it bias or interest or lack of interest has been brought up by the evidence. I mean, I think certainly both arguments support that, but we're talking about the pattern, and the pattern, I think it actually would be very confusing to give this charge in the manner in which it is patterned, because it does talk about bias and bad acts, and that doesn't comport with the evidence. So I'm not going to give it in this manner. I do think the issue of whether you call it bias or interest or lack of interest in the case has already been given at the beginning of the charges, and so I'm just not going to give 131.40. I think it would be very confusing. It doesn't really comport with the evidence in the manner the pattern provides. So, all right. So we'll move on to 131.45, and I think we've already talked about this. We already have this we've already given this earlier. Let me just make sure. You moved to 131.45. Okay, we're good. All right, let's move on then to 131.47. The defense has requested prior statements.
I don't have any objection.
All right, and let me just read it. Anything further, Mr. Cruz, you want to say in your request?
No, ma'am.
Just as this, all right. All right, I thought that, don't we already give this? I mean, I don't have any problem giving it, but I want to say we already, I feel like this is in our
It is. It is.
Yeah, okay, I'm not gonna give it twice. So
So
let me
just
just find it, what page we're on, but we already give this. Okay. Yes, it is. It's the bottom of page 9. Yeah, okay. So we're not gonna give it again. We've already given it, but your request is granted. Okay. 13190. Is that not also in the? Okay, that's not typically in there. I give it all the time. That's why I'm sort of thinking. Okay, 13190. Both parties have asked for 13190. Mr. Bolden, anything else?
No, Your Honor.
Okay. About that. Mr. Cruz, 13190, single witness. Anything else you want to offer with regard to that?
No, ma'am. No, ma'am.
I will give it. 13216, statement of defendant. You both have requested it. Right, I think at least the while in custody is appropriate.
Was it shown that he was in custody in that video?
Yes. The evidence was presented that they asked to remove the handcuffs, and that was shown. Yeah. What's 134? Okay, we're going to pull up 134. You both have asked for this. Mr. Golden, anything further you would ask for?
No, Your Honor, I think that both of the parentheticals would be applicable here.
So how are you asking it for it to be read? Obviously, we're going to get rid of OCGA 24.
Sure. Just exactly as it reads.
Statement was voluntary, comma, if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. Is that correct?
Yes.
Without the parentheses.
Yes.
All right, Mr. Cruz?
I'm reading it, Your Honor.
Okay.
1 second.
I just asked both of them how long it would take. I guess I haven't heard that. I mean, I don't know that they can get to it. Okay. Oh, okay.
All right, no objection. Obviously, we're removing the limiting instruction conditional admissibility language.
I was just reading that 13450. I don't think it applies, but I mean, I'll hear from you if you think otherwise.
No, it doesn't apply to that.
Okay, so are you satisfied with the way you both have asked for 13216? Are you satisfied with how it's written there without the parentheses?
Correct.
Okay, we will give it 13217. Both parties have asked for it. I think I'm going to, as you go through 13217, next page 23, the top, I'm going to get rid of the statement in determining voluntariness because we basically said that twice, and I don't want it to be confusing. I don't think we need that, but I'll hear from both of you. Mr. Bolden, do you have any objection to just 13217 as
No, Your Honor.
on 22? Okay, Mr. Cruz?
I'm reading it, Your Honor.
This is a request by both of you.
Okay, you're saying on page 23 at the top, you were taking out.
Yeah, it's been said several times, and I just think it's.
Okay. But otherwise, I have no objections to the vote.
Okay. All right, let's do 13218, next page, page 23. The defense has requested this one.
And Your Honor, understanding that Mr. Cruz and I might disagree over the legality of the detention based on our motions back in the fall, I would object to this. I don't think this is the type of situation that charge is designed for. If the court were to give it, I would ask that it read as follows. You may consider the duration and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made, but not give what's in the parenthetical.
You offered this.
Just double check it, please, Your Honor. I would request it, but I would leave it to the honorable court's discretion.
I don't think it fits the evidence. And, I think it would be confusing. There's been no evidence concerning this particular kind of a charge. So I'm not going to give that charge. 132.19, burden of proof as to voluntariness. Both parties have requested it.
I don't have anything to add.
Right, anything further?
Just checking the language, Your Honor.
Right.
And I know I request, I just always double check the.
I know I'm going fast. I want to make sure you get a break before 2:30. So.
I'm fine with it.
All right, let's go to the next one. Constitutional rights. Both parties have requested that. We'll cross out her just for starters. Word her. Cross out she. Well, first of all, any comments on 132.21?
No, Your Honor.
All right, what about, you both requested topic 24 where it says anything, and I'll cross out she, he, said, wrote, signed.
I mean, I think if I remember correctly, when Agent Bigham read Mr. Faust's rights, she used the word said. And so I don't think wrote or signed are necessarily applicable.
I have no objections to the language, Your Honor.
We'll just cross out the words wrote and signed, and obviously the word she. Okay, well, the next one, 132.40, the defense has asked for this.
I think that's a.
We've given that in 132.19.
We did give that in 132.19?
Well, it's basically the same thing.
I think 132.19 is specifically to voluntariness. 132.40 is in regards to just the Miranda rights as a whole. Because I think with waiving a right is intelligently, voluntarily, and a little missing one. I want to say freely, but I don't think that's appropriate.
I would say that the state does not have an objection to 132.40.
All right. I mean, it is a bit redundant, was really my hesitation. And I'll just, this is why. 132.19 and 132.21 deal with all of the things that are in 132.40, but.
Whatever the honorable court's rule.
Well, you've requested it, and even though it's redundant, that was really only my concern. But if the state is not objecting, I'm not going to make a big deal about the redundancy. It's not overwhelming, but that was only my concern, not that it isn't the proper law. So we'll give it. 132.50, both parties have asked for this.
And so, yes, my only comment, Your Honor, is to just get rid of the parentheticals at the end.
I have no objection to that, Your Honor. And 13270, I would ask to be removed. I don't know.
You're going to withdraw that?
I am.
Okay. Okay. So I guess my only concern, even though you both have asked for 13250, is again the issue of redundancy. I mean, we're sort of saying it over and over again, and in just slightly different ways. And so that's my only concern. But I'll hear from the state first, and then Mr. Cruz about that issue.
I mean, I would agree with the court that it is redundant. I just know that in every trial that I can recall in which a defendant's statement was played, I think there is just that extra caution to make sure a jury, and so I don't disagree with the court's the court's concerns about it being redundant, but given that it is all part of the pattern, I don't object.
All right, Mr. Cruz?
I would agree with the state.
All right, I'll give it. Let's go then to 25. We've crossed out 13270. We're on 134, limiting instructions. I don't think we had any of those.
Well,
Did we?
there could have been that 413 evidence, Your Honor. The state opted not to introduce that evidence, so I don't think it's applicable in this case.
I think we do have it in regards to Ms. Sims. You told me we could take it up at the charge conference in regards to her statement that what she tested was sperm, and we went through cross-examination, and then she said, well, we didn't, I didn't test it for sperm. I didn't know about the report that it was sperm. At the time, you told me to address it now. I would ask for a limiting instruction to the jury in regards to that statement that she made. And if the court is willing to give that limited instruction, I would ask for this pattern charge. But if the court is not inclined to give a limiting instruction, obviously this would not apply.
So describe for me, Mr. Cruz, I don't remember the conversation, but describe for me why you think her, I mean, you can certainly talk about the limits of her testimony if you want to do that, certainly, regardless of whether she's tendered as an expert. I mean, you can certainly go there if you want to. But in terms of the charge, tell me how it applies to the request for.
Sure. The charge only applies if the Honorable Court is inclined to give a limiting instruction in regards to the testimony. If the Honorable Court is not inclined to give a limiting instruction in regards to the testimony, the charge does not, it's inapplicable.
Sure, but I guess
to
what
this case.
limiting instruction would you be referring to? I guess that's what I'm
The
asking.
only thing I would ask, because there is no evidence of semen in this case. Outside of Detective Bigham saying that Chris Melton's semen was found, every other test, everything looked at it in the testimony, no testimony came out in this case that semen was involved. When Ms. Sims, who just did the differential extraction, she started saying, and I may say the wrong, I think she said either semen or sperm, but she said one of the two. She started using that language. And that's when I objected and discussed saying with the Honorable Court. I would just ask the Honorable Court to give a limiting instruction to disregard. And she corrected it after I made the objection. She stopped referring to it as that. But just to give the jury an instruction to disregard Ms. Sims' characterization as the DNA evidence as sperm.
Okay, thank you.
Yes, ma'am.
Mr. Bolden, would you like to respond?
Yes, Your Honor. I don't believe that's what this pattern jury instruction is designed to address. The issue with Ms. Sims the other day, I don't want to, no need to get back into the evidence, but like, I think if Mr. Cruz had requested a limiting instruction at that time, I could see it. But this is designed for extrinsic acts and the court telling them that they can only consider that for a specific purpose. That's where it falls in the pattern. It's not applicable.
I agree. I agree with you there. I agree with him in that position. Looking at it.
Yes. Okay, so before we get to the next page, both parties are agreeing that 134 does not apply right now. We're not going to give 134.
That I
You agree with that? Is that right?
purposes or against some parties and not others, or for some counts and not others. Such evidence may be considered by the jury for the sole issue of purpose against. It wouldn't apply to what I'm asking for.
Okay.
But I would still ask for that limited instruction if the honorable court is inclined. But this wouldn't apply. I agree with the statement.
Okay. So I'm going to get rid of 134. I'm going to say with regard to the limiting instruction, based on how both parties have described the moment, particularly Mr. Cruz, your comment that it is the characterization of the evidence. I think if the court got involved at this point with doing what you're requesting, the court would be inserting itself into characterizing the evidence, which would be improper. So you can certainly argue and bring up however you choose to the jury. It's not limiting for you, but I think in terms of the court charging the jury, it would be improperly inserting the court's opinion, which it doesn't have, of course, but sort of suggesting the court had an opinion on the characterization of the evidence, and that's not proper. I'm just going to do it in that way, but I'm not limiting you in describing however you choose to have the evidence played out. So I'm not going to give 134. Both parties have agreed to that. Let's talk about 134.10, which does require 134.
I would withdraw that, Your Honor.
Okay, I don't think it fits the evidence. Okay. All right, so the state is withdrawing that next one. All right. So now we're going to the next page, the middle of the next page, which is 134.20. And this was defense request. So I'll ask Mr. Bolden first. Any comment on 134.20?
I don't think there's any of that in the evidence in this trial. I'd ask that it not be given.
All right, Mr.
I can withdraw it. I withdraw the request.
All right, we're going to withdraw 134.20. 134.30 needs to be withdrawn.
Yes, Your Honor. They will withdraw that.
All right. And the top of 28, of course, as well is withdrawn. 135.30. And this is the state's request.
I would just ask that it be given as charged.
Do you want the words or believability, which are in parentheses, to also be included?
Yes. Oh, I'm sorry.
You can offer your opinion. Go ahead.
Yes.
Okay. All right.
I don't have any issue with that.
Mr. Cruz, do you have any objection to how the state has requested 37?
I'm reading this statute
Okay.
and the pattern charge now, Your Honor.
I'm going to get rid of the words admissibility, maybe ruled on, et cetera, because that's not. Just that little part.
Well, I think this is the issue here because I'm just now seeing this wasn't DNA comparison. This was actually, and maybe I'm reading too deeply into it. From what I understand from true allele and DNA comparison, one type is where a human does it and they compare it. And correct me if I say anything wrong. True allele is like a computer program that just says, hey, this is the likelihood ratio that this DNA or this pattern of DNA compared to this person would show. I'm trying to use correct language. Would pop up among a random member of the population, if that makes sense. So, but we could give it. I have no objection to it.
All right. I think it fits the evidence, so I will give it as charged then. All right, the next one is defense's request, 140.10, definition of crime. That should have been given earlier.
It was.
Okay, so I'm not gonna do twice, but I'll grant your request, but it's already been given. 140.15, state's request.
And Your Honor, I the only thing that pops into my head with this request is the burglary count where we've alleged enter and remain within the dwelling house of another. Okay. I know sometimes it's almost maybe it's almost better to wait and see if they have a question about like the and or conjunctive versus disjunctive. And so I would be okay with the court not giving it, withdrawing that request at this time. But again, that I know that does happen from time to time, and then we have to give additional instructions. So that I think that was the rationale behind that.
Okay, so you're going to withdraw it, but that does come up from time to time. Yeah.
Well, I would object to the instruction as a whole, because from what I understand from the indictment, everything is charged straightforward. And with the entering and remaining inside, I believe that's the state's theory of the case, that not only did Mr. Faust enter, but for a period of time, he remained inside and did these acts.
Okay. Any response?
Yeah, I mean, it's the state charges in the conjunctive can prove in the disjunctive, and I think that's very well established. But I think given all the other confusing aspects of the law, I don't necessarily want to interject another one unless they specifically ask. So I guess that's kind of the dueling concerns that I have.
Well, I think that it's probably best to address that issue this way, to not give it as charged. I do think it is probably confusing, and I agree with you, Mr. Cruz, in the concern about giving 14015, but it is an accurate statement of the law. And so I will just say this: if it comes up in a question, we're going to have to talk about how the court needs to respond to the question. And it may be that the court has to respond to the question this way, because this is the law, but I'm not going to give it as a charge. All right. 14112 is request about a state.
I would withdraw that, Your Honor.
So that is withdrawn. 15010, statute of limitations. There hasn't been any evidence about statute of limitations.
Well, and again, this came up when we were talking about CODIS the other day, Your Honor. So on some of the counts would have statute of limitations issues, but that statute was told based on the date that law enforcement received the CODIS hit, and that is alleged in the indictment in multiple counts. I believe beginning with count 6.
Okay. All right.
Own. And so, I think that's a material element that the state does have to prove. Now, the question is, I don't know what the statute is on some of these crimes, or at least what it would have been.
It's 4 years for felonies. I think murder, and I could be wrong on the murder one, so double check. I think it's 7 years if the person is known. If the person is unknown, it's an unlimited statute of limitation.
Well, and that's not, there's no tolling language alleged in the counts alleging murder or felony murder. It's the predicates.
So for the underlying felonies, 4 years is what I believe the window would be. But double check me. I'm never too certain.
I guess my concern, I understand exactly what you're saying. I think we have to figure out how to do this right, because there has been no discussion at all, and no evidence, I should say, no evidence at all about the phrase statute of limitations. And so this would be the first time, right, the jury would be hearing that. And so
I think it applies to the indictment, because they will have the indictment and will have that language on it. And the state, that is something the state does have to, oh crap, we didn't get into that intro.
I guess in the problem is the language of this indictment doesn't talk about the statute of limitations in that sense. It talks about it in a different way. Perpetrator,
Yes.
the crime alleged was unknown to the state of Georgia. So, I understand exactly what you're saying. I just think we have to tailor this so it makes sense. And maybe we do it this way. I don't know.
Can I have a second, Your Honor?
Of course.
I may have a motion. I just want to look up something really quickly.
So, Mr. Bolden, I would imagine on page 30, you would want me to put all the charges, the accused is on trial for the offenses of, and list all the charges, right?
Yes.
Okay.
Then I think it would, what I would then ask under Georgia law, prosecution for the offenses of,
And then list them all. Okay.
and then,
Prosecutions for these offenses.
well, so this is confusing. I agree with the court. So I would say that laws of our state sets a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for, and I would ask that the court read all of them, and then say that under Georgia law, prosecution for the offenses of, and then start with count 6 burglary, count 7 aggravated sodomy, count 8 rape, count 9 aggravated assault, count 10 aggravated sodomy, count 11 arson, count 12 possession of a knife during the commission of a felony. I don't necessarily know that you have, I'm asking the court to read those count numbers, but say that under Georgia law, prosecution for the offenses of, and then list those 6 or 7 offenses. Those offenses must begin within 4 years after the offense has been committed. And then I think maybe the court could see where I'm going from there as to how to tailor it on 150.11 and 150.12.
Right, and I'll hear from you, Mr. Cruz, in just a minute. I'm trying to figure out how to do this. So you go from under Georgia law, prosecution for the offenses of what's in count 6, 7, 8, 9, 10, 11, and 12 within 4 years after the offense has been committed. In calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that B, the person committing the crime was unknown.
Exactly.
Get rid of everything else. And then we can talk about whether the language, if you find from the evidence that this case is not filed, blah, 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 we can talk about where that goes. When the statute of limitations is, when the statute of limitations is raised. I think we just say the burden is on the state. Get rid of when the statute of limitations is raised, because it hasn't been raised.
No, and I think of it as like a venue issue. You know, the court's always going to charge on venue as a jurisdictional fact. I think that the statute of limitations is a jurisdictional fact as well. And so that's why I think it's, even though it hasn't been raised, that it's important to put that out there.
What is your position on the language? If you find from the evidence that the indictment or accusation in this case was not filed within 4 years after the offense was committed, it would be your duty to acquit the defendant.
So I don't think that that is tailored to this case. I would say that, again, going back to 150.10, under Georgia law, prosecution for the offenses of, listing those offenses must begin within 4 years after the offense has been committed. I would ask the court not to give that last sentence. And then say that in calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that the person committing the crime was unknown. And I think that that would be tailored to the case and to the way that the indictment, has been drafted.
Any comment on what the state is asking for?
Where's that language, Your Honor? I'm looking for the language that you mentioned.
Okay, so we jumped around a bit. Let's go to page in your documents. Bottom of page 29 is the state's request 43, which is 15010. And this is what the state is offering. Now I'm at the top of page 30. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for the offenses of, and it would list 1 through 12. Next sentence. Under Georgia law, prosecution for the offenses of what's in count 6, 7, 8, 9, 10, 11, and 12, and of course the court would read those offenses, must begin within 4 years after the offense has been committed, and skip down. In calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that the person committing the crime was unknown.
Question. I believe did you say the paragraph where it says if you find from the evidence that the indictment or accusation in this case was not filed within blank number of years at the?
Yes, the state has asked to eliminate those sentences, and I think that's proper to eliminate that sentence.
The only thing I would say is because the state has that burden, I think the follow-up sentence, the person committing the crime was unknown. We're not going to argue statute of limitations, but in regards to the jury's understanding of the case and having the indictment, I would just ask for it to be present. But I don't think that's anything we're going to argue. But I think it kind of flows into 15011B.
Okay. I'm not going to give that portion of it. I do think it's confusing because on the one hand, we're talking about the sort of the tolling and then reinserting back in language. Well, if you find it hasn't been accused or indicted within a certain period, I think it's very confusing. So I'm not going to give it. But let me ask you, Mr. Cruz, before we get to kind of the rest of it, top of page 31, the state requested 45. I have eliminated the front part of that where it says when statute of limitations is raised and just put in there, the burden is on the state to prove that the offense occurred within the statute of limitations or occurred within an exception beyond a reasonable doubt.
I would ask for the statutory language, Your Honor. So I would object to that portion being removed. Not statutory, I'm sorry, the pattern language.
Okay, let me look at the pattern. Okay. That is the pattern? Okay. That is good. All right, this is the pattern. Okay.
And my response, Your Honor, would just be that because the statute of limitations has not been raised, that telling them that it has is going to be confusing. So I agree with the court to just start that charge 15012 with the word the. The burden is on the state to prove that this offense.
I think that makes sense. I think we need to start with the burden is on the state. That is the pattern with the exception of when statute of limitations is raised. All right, the next one is grave suspicion. Does the defense, defense ask, I don't know if the defense asked for that or not. I always have it in there.
I did ask for that, but I don't see it on.
It's right below, it's next. Actually, yeah, it doesn't have a title. Where it says facts and circumstances. Yes. Do you see, Mr. Cruz? So do you see 15012 on page 31?
I do.
Okay, right below the very first.
I see it.
We just didn't label it. Mr. Bolden, any objection to the court giving grave suspicion?
I mean, I always do. I would object if the court were inclined to give it. I would ask that it go up with all the other information about reasonable doubt. The state's position is that, there are cases that hold that it is unnecessary, that it is adequately covered by the court's charge on reasonable doubt, burden of proof, things like that. So I would object. Okay. But if the court were to give it, again, I would ask that it be related to to those pattern.
I think that makes sense. I've always felt that we've always had it at the end and it feels a little bit weird bringing it out of context. So I am going to give it, I'm going to grant your request, Mr. Cruz, and we'll put it in where all the other issues of the state's burden, the burden of proof is, I should say. We'll put it there. All right. The rest of this is, I'll let you all look at it, but page 31, and I'm rushing through because I want to give you all a little bit of a break. 31, 32, and 33 are the basically the new instructions. They're not really new, that the Council of Superior Court Judges has issued about how to talk about the indictment and going in the jury room and things of that nature. This does not vary, I would say, amongst the superior courts. This is the standard appropriate comments the court makes about these things. And so I'll ask you to look at them, but I always give these, every superior court gives these. This is the modern new version. The newest version is really at the bottom of 32, where it says these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. That actually was added in by the council. And so unless there's any comments you all want to make on those, we're going to keep those in there.
The only thing I would say on 31, where it says as to the 12 counts of this indictment,
okay,
if the court might consider putting as to each of the 12 counts of this indictment, and that's really splitting hairs. I realize that, but just the idea that it's not.
I mean, I think that makes sense.
Thank you.
Any comment on that, Mr. Cruz?
No, ma'am.
Okay. All right. And unless you all have anything further you want to add for the deliberation charge, again, I don't really want to add anything to the deliberation charge. I think and the Supreme Court, of course, approves the charges that are changed. I think they've come up with the language that is best. I don't really want to add or subtract the Supreme Court's direction about how to speak to the jury about deliberations. I think it needs to be uniform across the board. And so unless there's something we need to talk about, I want to keep it as is. Anything else? Okay. All right. We'll be in recess till 2:30. We'll see you all then. We're going to get this written up. Thank you. Okay. We're going to email it.
Welcome to all our new followers from our sister channel at Truth Talks Live. You're watching at Southern Sin, your home for true crime. Hop over and hit that subscribe button. Court is on a short break. Don't go anywhere. The action will be right back on at Southern Sin. True crime just got darker. Catch the full episode on the link above. Subscribe to At Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.